Hello, ladies and gentlemen. It is 5:34 p.m. Or sorry, a.m. Yeah, we don't say that very often. It is very early morning here today, ladies and gentlemen. It is July 4th, 2023. I hope everyone's having a fantastic day today. We're doing some FiveM roleplay once again. We are finishing and finalizing our deliberations. I do need to change my home. But yeah, we are finalizing and finishing our deliberations that we were doing yesterday. We had some message in the AM. We'll be reading those. But good morning. I hope everyone slept well if they're awake. It's a nice, clean 7:35 EST right now, AM. Beautiful. Beautiful. We're gonna go ahead and just take the normal Tahoe here. Can't transfer it to a garage at Juliet. But yeah, I hope everyone is doing fantastic. I am doing great. I just finished some barbecue, so I didn't get to eat it, or I didn't finish it. I just ate some. I just killed off some barbecue because I didn't get to eat it yesterday, and I'm feeling good. We got a bunch of time now. We're in the AM. We're pulling in the long hours. I'd like to get this deliberation done. We did have some messages from the lawyer who disagrees with my ruling. So we're gonna read a little bit of that and speak on that. Technically, it's metagaming because I haven't spoken about it in character, but it's fine. It's fine. It's not a big deal. Leadership wants the rules. It's a big deal. It's up to them. But for right now, it's fine. Right? So yeah, we're gonna head down to the courthouse, get our car set up. I am just gonna set up one escape vehicle just to be safe. I would like that and I do have a bit of time now. So buckle up, especially for the bod watchers. Like, what the fuck? 5 a.m.? Yeah. If you weren't here for the end of yesterday's stream, I did state that we're gonna have a double stream today. So I'm gonna be deliberating today, and then we have a meeting on Crane somewhere late this evening that we will be fucking attending, because I want to make sure that shit's done right. We got about 6-7 people on. I don't know if anything's gonna be crazy. I don't know if there's cops on. I didn't check. Not that you should. Hello, Sam. Welcome to the stream. Good morning, sir. How are you? Yeah, very early morning stream. I gotta get these deliberations done. So I need to make sure we're good. And I am a morning early bird, I think it's called. Not an early owl. Well, I'm both technically. Like I got up and immediately ate a full fucking supper for breakfast, and you know, I'm ready. Wait, I need a vending machine. Your food sucks.
Hello, friend.
You don't have a vending machine. You suck. Woke up early today. I was just playing some League of Legends when I got your ping. Hell yeah, brother. So yeah, right now we're just gonna be deliberating on the case, as my stream is lagging a little bit. So I'd like to, wow, these bananas aren't shit. Christ. Like, look how low they are. Who decided this was a good idea? It's fine. It'll tell me over until I'm there. Like, fuck off. I know the Sprunk is good. I shouldn't have bought so much. But yeah, I want to get these deliberations done. We have some stuff to read as well. Turn up the game a little bit for myself. Oh, that was unlocked. What just happened? I locked it when I was in it, and it messed it up. Nice. So yeah, I just want to finish Deliberations. I do want to get like 2 things set up because I'm going to be here for about 3 hours. So we're going to get into the morning crowd. So I want to make sure that I got my stuff set up. So I'm going to set up a truck, and I might set up a bike as well. It is 5 a.m. Welcome, Ped. Hope you're doing well. If you missed yesterday's stream, I said I was going to stream early so I can deliberate. Because this doesn't require other people, it's just me, right? So yeah, welcome, good morning. Well, good afternoon, I suppose, for the UK, I'd imagine. But yeah, we got a lot of stuff that we need to be doing still, and I need to get it done. And it's happening on stream because I like that. It's just more content. So yeah, that's where we're at. This truck's actually pretty quick. Before FiveM picks up, I'm busy 100%ing Fallout. Fallout 4? Dude, I was actually just thinking about Fallout 4. The word Fox, F-A-U-K, or sorry, F-A-U-X. The word Fox RPG comes to mind anytime I play that game, which is meaning fake RPG, right? Because your choices don't actually have meaning. I played a lot of Fallout 4. Obviously, I'm a big Fallout fan. But, like, man, it really annoyed me how, like, it wasn't actually an RPG with actual player choice. You know? Like, that kind of annoyed me. But, like, I beat all the campaign and shit. I don't know if I ever went for 100%ing. Alright, let's go and grab a truck to stash somewhere. Because, like, I loved Fallout 4. I think, I'd imagine I got a good 300 in it. Let me check, actually. Let me grab my Steam and type in Fallout. So, yeah, I got 245 hours in it. So, like, nothing to scoff at. But, you know, it just wasn't, a game I was going to put any more than 300 in. Because it wasn't an RPG, right? It was just a fake RPG. Where it has the pretending of player choice. So yeah, still a good game. Like, gunplay is some of the best Bethesda's ever done. And I'll tell you one thing. When Elder Scrolls 6 coming around, if I'm still streaming, which I fucking will be, we'll be playing it. We'll be streaming that shit. We're gonna be streaming Baldur's Gate 3. And I don't know if I'm gonna pick up Starfield. We'll see. Because Starfield's pretty fun. It looks pretty fun, I mean. Nora. So I'm gonna grab the Kara, as this is my, like, 4x4 fucking safe vehicle. Starfield looks epic. Yeah, I think the only thing I'm, like, mega excited for is, like, the ship customization and, like, how much ship flying you can actually do. I think that's the one thing I'm looking for. Nice, I do have a shotgun in that, if I need it. Yeah, it's not going to be a pre-order. I'm going to wait until, like, we actually get some reviews on it. Because the gunplay is obviously going to be really fun. But, like, is it going to be another fake RPG? like where dialogue options, like you have them, but like they don't really do much. Like it's always to the end option. It's kind of like what Hogwarts Legacy did, where it's a fake RPG, where it shows you like you can have choice, but you don't really, because they're really hard to make. That's why I'm so excited for Baldur's Gate 3. You know, just out of due diligence, this fucking... We did just, you know, put someone back to jail while we're waiting. There's always room for caution. This is all good. And we'll clear as we're going, so no one can think. What's Baldur's Gate 3? Oh, you're gonna find out in about a month, Sam. So Baldur's Gate 3, we played this 2 days ago, or 3 days ago. But Baldur's Gate 3 is a RPG, where your choices actually matter. It is based off of the 5e system. It's Dungeons & Dragons. And, it is amazing. I've clocked, in the early access, which is what it's in right now, I've clocked 310 hours. And man, is it fun. Like, one of my favorite games at the moment. It's not even fucking out yet. And we will be streaming it for about 2 weeks. When it comes out in August. How much is it gonna be? It's retail, so $79. It's a fucking massive game with 170 hours of cinematics and 2 million lines of dialogue. So, you know. So it's $79 Canadian is what it is. Alright, we're all clear here. Alright. We'll have to get food at some point. But, go ahead and turn off comments off of the unhook. There we go. And, bop. Ooh, we should move this. There we go. So, we have finished, actually. We had finished.
Sonny boy, put your hand down.
So I think we're done. Like, the only thing we're hearing now is closing arguments. So let's hear their closing arguments.
Thank you.
Ladies and gentlemen of the court, and they, thems too, I guess. As we come to the end of this trial, we must reflect on the gravity of the defendant's crimes. His actions, taking the mayor hostage, perpetrating a massacre at City Hall, committing a bombing at a bank. Mr. Jones, please stop pointing.
Sam, if you want, 2 streams ago, I did play it at the end of the stream. Let me see. Like, when specifically that was. Like, I think it was... Yeah, it was here. So, we had FiveM first, and then we switched over to Baldur's Gate. And then this is what the game looks like. I'll just do this.
We wasted Sylvanas taught us a lesson by
Nice. There we go. So yeah, this is kind of what the game looks like. It's still like a top-down, but it's not like you can zoom in and you can have mobile stuff, which is funny because you play League of Legends. It's not like a MOBA. Well, kinda. It is click to move, I suppose. Is League of Legends click to move? Yeah, it is, isn't it? Yeah, I'd recommend just watching when it comes out. So for me, I'm gonna get it 72 hours early. Because I applied the early access. So I will be playing it on July 30th of this month. So super, super, super excited about that. Anyway, closing arguments.
And committing a massacre of law enforcement at a hospital, as well as threatening newborns to kill them.
Yep.
His actions have scarred our community and our trust in each other. The evidence presented has been damning. We've heard from witnesses who survived his reigns of terror, his attempts to escape, massacres, his attacks, even his own lawyer testifying against him, and to his depravity. There is no doubt of his guilt. We have a responsibility to ensure that justice is served. We must send a clear message that acts of violence and terror will not be tolerated in our city. The lives lost and families torn apart demand nothing less than accountability for the defendant's actions. Remember the pain and suffering inflicted on our community. It's our duty to stand together, condemn these atrocities, and deliver a verdict that upholds our commitment to peace and safety. Mike Randel must not walk. Thank you.
Mike Randel, closing. Ooh, what frame is my Discord on, I wonder? Hold on. Oh, let's see. We're all good.
Ladies and gentlemen of the jury, all I've heard today is a lot of speculation within law enforcement, failure to remember key information such as injured officers. They can't be bothered to remember who got hurt. How can they be bothered to accurately really describe what occurred?
That's a good point.
My own lawyer is a rat, and he should be punished for it.
Jesus
We
Christ.
should not have government officials, people that work for the state, that turn on the people. This is why I should be found not guilty. If law enforcement did their job properly, they would have processed all the information and had accurate reports. If they are forgetful, then how can they be confident that I committed these crimes?
All right.
And that is all.
Thank you. And that is everything, ladies and gentlemen. So, hold this over here. Okay, so we need to come back. Let's roll it back. We need to come back to here. Enter witness Dimitri Jones. So, Dimitri Jones is making an argument against this, okay? So let's read verbatim what was said in courtroom. Now, this wasn't verbatim writing, but this was me writing everything that I thought would be relevant to my deliberation, okay? Because some words are just words. The DA's office's argument against the ACP, which is the attorney-client privilege, is that Mr. Jones, under attorney-client privilege, proceeded to waive the privilege because he was made aware of several points of information that endangered other people's lives. As a result, privilege was fully waived and it's no longer entitled, okay? So, per my understanding of privilege, which is attorney-client privilege, you cannot, the lawyer cannot, waive the attorney-client privilege unless there is a crime fraud exemption or the person said that they are going to commit a crime. Now, does that mean you waive the privilege in its entirety? No. You say, hey, police, this person is going to commit this crime here, today, at this time, and he just told me about it. That's fine. You don't get in trouble for that. However, testifying against your client is out of the scope of that. What should have happened is that the defense attorney, the defense attorney should have recused themselves or removed themselves from being their lawyer, told officers about the crime that was going to be committed so they can prevent it, because that's fine, and then that's it. Everything else is protected by attorney-client privilege, right? So, the defense retort is that he cannot waive that right. That is my lawyer. I have a right to privacy between my lawyer and myself. You said he had the right to tell law enforcement this, but referring the court case is out of that capacity. So he's basically saying it's out of the capacity for him to testify at a court case completely. Okay? So, my ruling at the time of yesterday was Dimitri was correct in advising the police that a potential act of terror or crime was going to be committed. However, this does not give the right to Mike Randall's attorney to waive privilege in totality, okay, as a whole. As that right is given in specific circumstances, such as the client waiving the privilege themselves or crime fraud exemption, which does not apply to waiving the attorney-client privilege in its entirety. Thus, everything that Dimitri has said has been struck from the record. I'd also like to note that I don't believe the Patriot Act allows you to revoke the ACP. And that was another reference. Okay? That was another argument after this one. Okay, but yes, I don't think that happens. So Dimitri actually messaged me in Discord, and he said, "I skimmed through your deliberations and deliberation discussion out of curiosity. In a moment, he started sending pictures of Aston's car, the courtroom, and the courtroom that could currently have me in it, representing someone, as well as civilians watching when this was broken." So in this first paragraph, he's basically stating that the third party exemption, which means, and specifically states, because I was literally just reading on this yesterday, is that if your client tells you something in private and tells someone else in public, that doesn't mean it's private. Now, I want to look and see that specific. Give me a second. Yeah, I want to see that specific writing. Just give me a moment. I think it's called third party. All right. The attorney-client privilege when a third person is present. This is from nolo.com, which is a legal website. The attorney-client privilege prevents people from revealing confidential communications between defendants and their lawyers. But what happens when a third person is in the room during a meeting between the attorney and a client? The general rule is that by allowing a third party to be present for a lawyer-client conversation, the defendant waives the privilege. That generally means that a prosecution can force the third party to reveal the contents of the conversation. Keyword here, third party. Well, Jeremy, why is that third party very important? Well, it states that the prosecution cannot force the attorney to testify, but they can force the third party. Despite the general rule, there's exceptions in most states. In general, when a third person is present, the attorney-client privilege continues to apply if that third person is there in order to aid the cause. Put more specifically, the third person must be present when fulfilling the role that furthers the defendant's legal representation. The person might be a part of the lawyer's staff, an outside party with relevant expertise, for instance, an investigator, an interpreter, or even a relative who acts in an advisory role. When determining whether attorney-client privilege applies to the conversation involving a third person, courts generally consider whether the defendant intended the communication to remain secret and the precise role of the third person. See, while Kenneth is arguing, and I know that you can't see what I'm reading because I don't want you to see it, but what Kenneth is arguing, or Dimitri is arguing, is that just because he brought up specific information about the case means that he can talk about the case. That is not true. Because what what Dimitri is basically stating is what he said, right? So he's speaking to what was said, he's not speaking to the evidence being factual or not, right? And if he is, regardless, I still don't think that he should have testified. So yeah, that is that. He moves on to say, "This was one of the days we had a bomb threat, which to me made it a credible threat. Everything we had to discuss was immediately turned over to the police, as well as text messages that led to that. I think that violates attorney-client privilege. There's a lot that led up to it that wasn't brought up because this was over a month after the fact. That doesn't mean you're right. Specifically, what that means is that the prosecution didn't fully prep their witness and didn't go over this preemptively, and also you can't use we had this in the past as an argument when you didn't present it in the court case. He specifically mentioned harming the chief of police, who I immediately notified and handed the phone over to see the pictures and text himself. I mean, I think that would be fine if he included the pictures and text, but he spoke about a lot of things. And I can't read them all. Sorry, I can't re-listen to it and refresh my memory because I cannot adequately remove that from my brain if I do that. Right? One instance that the attorney can break privilege is the following. The client disclosed an intention to commit a civil or criminal wrongdoing that could endanger someone. Where is that written? Where is that written? Let's Google that. Instances where an attorney can break privilege. Not privileges, privilege. Come on. Okay, USA. What are the limits? So this is from LRW Law Firm, which have a beautiful website, by the way. What are the limits of attorney-client privilege? The attorney-client relationship is one of the strongest and most confidential professional affiliations. When someone retains an attorney, the attorney enters into a legal binding agreement in which he or she cannot disclose the client's secrets or information to others. This agreement is the attorney-client privilege. Confidentiality is key in your relationship. With a personal injury lawyer in... Wait, what? Okay, that wasn't relevant. So that client feels he or she can open and share things to the lawyer, yet not everything a client says falls under this privilege. Okay. Basic of attorney-client privilege. In Tennessee, and in most states, the attorney-client privilege rule applies when a potential actual client receives legal advice from a lawyer. As long as an attorney-client relationship exists, the client is intended communication to be private and confidential. A person cannot expect an attorney-client privilege to exist when asking a lawyer friend for advice at a cocktail party. The lawyer must be acting in a professional capacity at the time of disclosure. If the attorney-client privilege does exist, the lawyer cannot disclose the client's secrets to anyone outside the firm unless the lawyer has the client's consent to do so. The client has the power to waive the attorney-client privilege, not the attorney. Even if after the client stops retaining the attorney or the case ends, the privilege remains in place. In most cases, the privilege stays even after the client dies, unless there's exceptions. So then she speaks, or I don't know what gender this writer is. Then they say, crime, fraud, exemption. They speak about crime, fraud, exemption. The attorney-client privilege is something that belongs to the client, not the attorney. Therefore, it's in the client's intent whether, when speaking to his or her attorney, that can determine whether the crime, fraud, exemption, or other limits to the rule exists. Sorry, what? Therefore, it is in the client's intent when speaking to his or her attorney that can determine whether the crime, fraud, exemption exists. The crime, fraud, exemption holds that if the client is intended to commit or was in the middle of committing a crime or act of fraud and communicated this intent to the lawyer, the information is not under privilege. So this is specifically, and I've already read this, but this is specifically speaking about the thing that was just said, not everything that was said. Okay? Okay. In other words, if a lawyer learns that his or her client intends to commit a crime or cover up a crime, the lawyer has the right to disclose this information to the authorities, which I have already spoken about and agreed with. The prosecution can subpoena the lawyer and force him or her to disclose this information. In standard situations, an attorney does not have to disclose privileged client information, even under oath, to tell the whole truth. Further crimes and fraud, a lawyer will have the right to disclose that can include destroying evidence, tampering with a witness, concealing income, threats to someone, and perjury. This exemption can extend past crimes into civil torts or wrongs, as well as most civil wrongs are crimes anyway. Most intentional civil wrongs are crimes anyway, such as trespassing and assault. A client who's yet to commit a civil or criminal wrongdoing cannot disclose this information to a lawyer and expect the attorney-client privilege to keep the lawyer silent. Most states will permit an attorney to break confidentiality agreement if someone is in danger. If the information has to do with a past crime, it is most likely privileged. The same is true if the client is merely speculating about a possible further intent, a future intent. It can be difficult for a lawyer to distinguish between musings over a future crime and actual intent. Other limits, and this is the last paragraph. The law will not enforce attorney-client privilege if the client cannot reasonably expect a communication to be private. For example, sending a letter to a lawyer and disclosing incriminating information is not a type of communication that is guaranteed privacy. Speaking to a lawyer in a public place with other people is another example where the information may get out without consequences to the attorney. Otherwise, a lawyer who breaches attorney-client privilege could face serious consequences for an ethical violation, such as disbarment and criminal charges. So, this is coming from a law firm. All right? This is posted in General Law Forum on August 6, 2018. Now, to my understanding, there is things that Dimitri said which was not specifically stating about the crimes itself. However, I think I need to watch it now. Let me think about this, actually. So what I could do is I could make my deliberation and decide without this affecting my case, and then I will re-review and see if his stuff can be removed. I'll do it that way. So then nothing he said has an influence. So yeah, the thing that I just read, which was from from Dimitri, which says the client discloses an intentional commit crime, civil wrongdoing, could endanger someone. So yeah, we'll rewatch the thing, but not right now. Not right now. Okay. Okay. So update. I will be reviewing the footage after I have decided what to do to see if my ruling is correct. Okay. Alright, I need you to go use the bathroom. I'll be right back. All right. Oh shit. There we go. Cool. Controlsy does that. Awesome. I'm good on food still. All right. All right, sorry. Okay. So, enter Corporal Lucille McDougan. Okay? Called as a witness. Involvement. So she was leading and the handling detective for the entire case. So this person's going to know the most. That entailed writing a report, investigating all scenes involved, adding evidence to the investigative report, okay? And we already looked at all the evidence yesterday. Multiple fingerprints from Mike Randel. Oh, hold on. All right. Okay. Anyway, sorry, I was just messaging Dimitri. So, adding evidence to the investigative report. So, evidence. We have multiple fingerprints from Mike Randel on various scenes across the state. One scene was involved with the kidnapping and torture of Jeffrey Harris. At the time he was a mayoral candidate. There was a shooting at the courthouse where some workers were shot in the lobby. We found Mr. Randall's DNA on scene. So far, we have a lot of evidence. A lot. We have a lot of evidence. We have a lot. Because, like, all this is saying, right, is this is trying to remove doubt from me. Right? So, fingerprints on scene at various scenes. At various scenes, right? So, fingerprints, DNAs, cigar butts, DNA on multiple shooting scenes, okay? So let me see. This isn't really relevant here. So then there's this evidence here. The Big Wreck Army evidence, which we can prove is factual because of this. His DNA was on scene, and this note was there, okay? And then if you go to his Twitter, Mike Randall's Twitter, you can see one of the pictures is this, which I believe there's a blow up here of that. Yes. So on his Twitter, there is this picture, which is under his handle, and it says down with the government, and there's a picture of his face, okay? And then we have these pictures here. This is his mugshot. This is the one taken off Twitter. I believe this is also something that was taken off Twitter. Hello, Kenneth. These are all the things, okay? So, we can connect, because of those 2-3 pieces of information, we can connect this here to this here, which this connects to his mugshot, which proves that the person who owns that Twitter is him, which means that we can use this evidence against him. So we can prove without a reasonable doubt right now. Well, maybe there is still a reasonable doubt with this thing, but we can prove at least he was there when the mayor was taken down. The candidate was taken down. We can prove that. We can prove that he was there, without a reasonable doubt, that he was there when all these cars were blown up. Okay? Which gives us a suspicion that he was involved because of what he said here, alluding to and trying to take ownership for this attack. Okay? Then there's a lot of, you know, emojis which could lead to certain things, but that's circumstantial, I think. And then there's this. So why is he on scene when someone else is kidnapped? And this is the mayor. Right? So this is May 19th and May 19th. I don't know what times they were. Can I check that? No, it wasn't missed. It wasn't submitted. I can't look on Twitter myself. I'm not an investigator. I can't do that. So all we know is they're both on 19th. And we don't know what order this is. But we know that he was there when the mayor was downed with many injuries. We know that his DNA was found on scene. And we know he was there when he was kidnapped and alive. Okay? That is fine. We already spoke about that. So we noticed the tweet put out by the tweeter, Big Ray Army. We confirmed it was Michael Randel later. They didn't state this, but I'm pretty sure I just confirmed it myself. Tweeted out the location of the mayor. Was not a miss. Okay, so you're speaking to, this is speaking to evidence that was not submitted. Pretty sure, unless it's in this fucking big list of shit. Wait, no. This is all admissible. This is probably inadmissible. We can't look at anything on his phone. Admissible. Okay. So everything in here is admissible. Like, we can use this. So we're gonna hope that McDougan had the foresight to include all the Twitter texts. Yep, this is just the stuff. Yep. Okay. Okay. Awesome. Yeah, but I can't look at those texts until I have made my deliberation and decided what I'm going to do, and then I will re-review what you said in court to see if it was admissible or if it was against the privilege. I need to do it after because it cannot affect my deliberation. And since I've already forgotten what you said, because I don't remember, not as clearly as I would like, that I'm going to deliberate, decide, and then watch that. And if it's admissible, I'll allow it to affect my decision. And if not, I will keep it where it is. Um, 15 minutes ago. Alright, can't look at that, can't look at that. Ooh, I can look at the Twitter here. Nah, not enough. Yeah, I wish they had included the times, but they didn't. Okay. Okay, so, I need to pause the music because it's too much. So this is admissible. It's just, I wish they included a time. At the time, we immediately moved to the location to find a mayor. On scene, found Harris on the ground, multiple bomb-making materials. Yep. Speaking on the rest of Mike Randel, I know we chased him across the state with Paul Randel. So, like, it's provable that, like, he fled, right? Like, he fled. like, we had 2 officers state this, and at any point he didn't say that was a thing, but it wouldn't have been flight from law enforcement because he wasn't driving. Speaking on the City Hall massacre, when arriving on scene, we saw multiple shell casings on the ground, multiple dead bodies from workers that had that handle things in the lobby. We found a cigar inside the courthouse, and when we swabbed the cigar, we found Mike Randall's DNA. Okay, and Cross, why aren't you able to recall those names? So that was the question. Oh wait, sorry. I need to read this as I wrote it. So Mike Randall asks, who were the 4 injured injured officers at Pillbox? Lucille says that it was... Ooh, did I not write it? She lists the ones that she lists previously. So James May, John Seed, and herself, and the one she forgot, which was up here. I'm pretty sure that's what she stated. Why aren't you able to recall those names? Because she said she forgot 2 of them. Lucille said, because I was shot and sustained a small amount of memory loss. M said, Mike Randall, is that his name? Yeah, okay, Mike Randall said, why aren't you able to recall? So you're saying that you received memory loss, but you're testifying in this case. Lucille said, I received a small amount of memory loss. The injuries weren't major, but they did cause me to not remember pieces from the scene. And then, like, that was a good point. And then the district attorney redirected and said, is there any doubt that a person involved in a shooting at Pillbox was Mike Randall? There is no doubt. Okay? So, in my mind, like, that's an amazing redirect, because the argument that he's stating is that her memory is to be like shot down. But the problem is that she doesn't forget anything about this. So, like, maybe he's, like, trying to combat this as well by saying, like, her memory isn't trustful, so why would you trust this? So that's also a good point to be made. Because, like, how does she remember that, but not remember who was on scene? So, yeah, that's something to keep in mind. Exhibits prove that Mike Randall owns the Twitter account alleged in this case. Nice. Enter James May. Called as an expert witness. James notes that he's not good with dates. James was told that the mayor, a major kidnapping was happening. Information was gained from the Twitter that a kidnapping location was at the Ultras camp. On entering the location inside the building. I think this isn't, like, there isn't anything here in the redirect. There was no redirect. So... like, this is just confirming what McDougan just said. So we can count that as true. There still could be reasonable doubt, though. Enter Bobby Dean, speaking on the rest of Mike Randall. Was told that Mike Randall was potentially up to a terrorist act. Confirms McDougan's reports on the events that took place at the pursuit, ending at Pillbox. And this is where new information comes up. Which is James May requested backup as Mike Randall was barricaded in the back of Pillbox. When I arrived on scene, May and McDougan were downed, which speaks to why neither of them testified to this. We locked down Pillbox. Randall was spewing threats saying he would injure more officers, and if you do not leave the scene, he was also calling threats to killing newborns in the hospital, including sick kids. Pretty much wanting to take down the whole hospital for his thing. That's speculation. I'm going to go ahead and strike that. The DA asked if Bobby Dean was believed that Mike Randall would carry out these threats. And then he said, without a doubt, 100%, as 4 officers were already downed, waited for more officers to come on scene, and breached. And then we had recalled James May. Did you process any evidence? I was in charge of forensics. And this is from the defense. What experience do you have? Not my first time, and still not the most experienced person. Is it possible you made a mistake? Yes. Cross-examination was, did you do training for evidence process? And he responded with, I'm the person in charge of forensic work. I was not trained by someone else. You are experienced with this equipment, correct? I spent some time in the lab learning how things work. Was this your first time handling evidence? No. Is it a likelihood such as fingerprints can come back to a different person? The likelihood of that happening is very low, and I would consider these to be very accurate. And then McDougan was recalled. How long have you been in law enforcement? About 4 years. Have you ever left out key information? This is kind of badgering a little bit. Is this okay? Is it possible that you could leave out key information? It is possible. Did you collect any evidence at the courthouse? I collected and bagged the evidence. May he processed it. What evidence did you collect at the courthouse? Shotgun shell, cigar butt. Did you check anywhere else? Sweep the courthouse, found lots of posters, said this, and other than that, no cases. And that's it. So I need to sneak over to my judge stuff document. But you can't see, not allowed. Because we need to talk about reasonable doubt. So, okay. The truth is in the facts, which must be proven by the evidence beyond a reasonable doubt. Okay? Needs to be beyond it. It's not just like, we have this circumstantial evidence and blah, 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 he's guilty. No. It needs to be beyond it. Okay? I'm basically deciding how far. Now, here's the deal. We have a lot of evidence, okay? We have a lot of actual evidence. All the evidence in here was admissible. Other than the text messages. So, if we look at this, we know that Rick is the person. Okay? So, he is claiming, because of the evidence we have, he is claiming that he took this person hostage, okay? I don't know what the context of this. So this was a picture taken on scene of a different scene, and this is inadmissible. This doesn't lead anything to say that he was involved, because I've never heard anything about the scene. This is over by the fucking courthouse, and I don't recall any evidence to being on scene. And his DNA was found on scene. Yep, DNA was found on scene. So we have DNA at one explosion. Okay? One explosion. We have DNA at another shooting at the courthouse, including him taking a thing for it. Yep, fingerprints. But for right now, both of those are public places, right? You would have found a bunch of fingerprints there. But the cigar butts is not what you would find there, okay? And here, I'm pretty sure Mike Randel was actually found on this scene. And also his DNA was on scene. So that is his DNA at 2 bombing scenes. 2! Which is huge. 2 bombing scenes. And in totality, 3 shooting scenes. Okay? Because the bombing I would consider a shooting as well. So 2 bombing scenes, his DNA was found on scene. And he was found here, to my memory, he was found here. And there's blood-making glands, and the person is there. So let's look back. Alright, they found his DNA on scene, but he wasn't actually there. Interesting. Wait, no, hold on. We have the investigative report, right? Yeah, let's read this. We're just looking for what's relevant to what I'm speaking about. Yep, here it is. We saw mayoral candidate Harris laying on the ground with significant injuries, and Dimitri Jones next to Mr. Harris. We detained Mr. Jones, and okay, sorry, I thought Dimitri Jones was the other guy. All right. So, yeah, that's pretty bad. So, is there a reasonable doubt, or is it beyond it, that he was involved with the bomb making? Okay? Let's write this down. Let's write while speaking. I should phrase this better. Hold on. Let me just copy this. We'll just do that. Is Mike Randel, does the evidence prove that Mike Randel was involved with the bomb making beyond a reasonable doubt? Okay? So, that is question number 1. That is question numero uno. Alright, is there anything else I need from this document? Roll the judge. Yep, trier fact. Okay. Let me see. Death penalty trials. I just did a bunch of shit on that. Yeah, I have this big 10-page document where everything I know about being a judge is in it. It's like my cheat sheet. Hearings, hiring, approving laws, chains of command, guidance, law for verification, warrants. Nope, I think we're where we're at. Okay. So basically all I'm doing right now is I'm just reviewing the evidence. Right? So does the evidence so let's list it. DNA was found at 2 scenes, at 3 scenes of a shooting slash... Oh, but let's be specific. Let's be specific. So... Show us, absolutely not. But... So DNA was found. DNA was found at the bombing of the bank. Okay? Belonging to Mike Randel. DNA was found at the torture... at the altruist... altruism? Where bomb plans were made. Bomb plans were found. Lists of government officials were found. And... Well, what else? Good list of government officials were found. And... Harris was found on scene, very bloodied. Blooded? I don't fucking know. Sure. Very bloodied, and was tortured. Oh, now you want to correct it? Well, how do you spell it? Bloody? No, bloodied. Blooded. I don't fucking know. Very injured. Jesus fuck. And government. Where bomb list was found, list of government officials were found, and Harris was found on scene, very injured, and was tortured. What else? I mean, I have it. Was there explosive stuff on this thing? Bomb making plans. Bomb making materials. Nice. Bomb making materials. Bomb making materials was also found on scene. Alright, Randel's DNA was found. Okay. Blooded. It doesn't sound right. Maybe I'm just reading it wrong. Hello, Adam. Hope you're doing well. Good morning, sir. Found at the Ultras camp where bomb-making plans were found. A list of government officials were found, and Harris was found on scene very injured. And was clearly tortured. Bomb-making materials were also found on scene. Okay. There was a shooting that happened at the courthouse where 3 individuals, yep, I'm gonna have to correct that shit, individuals were murdered. What's that? Anyway, 3 individuals were murdered. There was 3, right? One, 2, 3. I think it was 3. Yeah, because there's a dude in the corner too. And Mike Randall's DNA was found on scene. Okay, great. So he was his stuff was found on scene. And also, we also need to prove that, and they did, that multiple people were killed at that bank one. Right? Let's get back to text messages. They didn't list how many people were dead here. But it looks like 4? And that would show premeditation, right? So I guess now what we need to do is we need to look at stat sheets and see like if that's covered. I feel like the way my brain is going, it seems like this could be terrorism, but like let's look at the stat sheets real quick. Where are you, terrorism? Dude, is it like not just straight up here? And by the way, I'm pretty sure these don't work anymore. I'm pretty sure it's my fault. Yeah, it is my fault. Yeah, I don't know how to fix that. I'm sorry. Because I made this document. I feel terrorized. This terrorism. First degree murder. So an individual who acted with the intent to kill or cause bodily harm knowing it would result in death with premeditation. I mean, the dude had fucking plans. He was building bombs. Nah, it's on me. Y'all fix those? Alright. Thanks, Sam. Yeah, but where's terrorism? Why is it so far down? I thought it was on the top. There it is. So racketeering and that doesn't. That's inquiry shit. That's Dakota Rogers. I mean, act of terrorism: creating a mass destruction by means of explosive device or mass shooting in highly populated buildings, structures, vehicles, or areas to influence and assert a political or ideological change, instilling control or fear in the public. The man said, and I quote, we need to get rid of the government. He said it in court. I know I can control F, but I wanted to look for it. So making a bomb and using it at a bank, would you consider that mass destruction? Would I consider it mass destruction? It's destruction. It's a bomb. It's by means of an explosive device, but like, define mass real quick. Let's define Mass. A large number of people or objects crowded together. There's a lot of buildings. There was a lot of buildings there. Like, that's in a fucking whole plateau. Right? There doesn't seem to be structural damage. Yeah, but also you gotta remember this is a video game. If there was a dirty bomb that went off in there, like, could there be structural damage? And you're destroying funds of everyone who has money in the bank? I mean, regardless, it states creation of mass destruction by means of explosive device or mass shooting in a high thing. And it also says or. It says or here. Areas to influence and assert political or ideological change, instilling control. Or fear. Right? So, does him premeditating putting a bomb in a bank, blowing it up, and going around telling people that under my administration, because he said this in court, under my administration, this stuff wouldn't happen. Is that trying to assert a political or ideological change? Yeah, I would say fucking, like, trying to become a mayor is a political thing. Personally. And also, blowing up a bank would also instill fear. Maybe it wasn't his intent. Maybe I can't say that. But what I definitely can say is that he was doing it to influence stuff and assert a political or ideological change. Because even if this wasn't admissible, we also have the evidence of this scene here, where he had plans of taking down political officials. We had a whole list of political officials here. He had bomb-making plans. He had bomb-making materials. He was taking down the other mayoral candidates. He took down 2 of them. He took down Harris, and he took down the other guy. And that was on Twitter. That was over here. Oh, can't read that. That was here. Morty. Morty was also another mayoral candidate. So he was taking down mayoral candidates, and he said in court that he was running. Like, that was something that he was trying to do, or he implied it. So, let's go back. Does the evidence prove that Mike Randel was involved in the bomb making beyond a reasonable doubt? His DNA was found at 2 scenes where bombs were used. One scene had bomb-making materials, information, and plans, and the other scene had a bomb that was blown up. I think, beyond a reasonable doubt, that is a yes. Okay? That is too much information to just ignore. Beyond a reasonable doubt, yes. He was involved with bomb making. Beyond a reasonable doubt, in my mind, yes. DNA was found at a bomb in the bank belonging to Mike Randel. Yep. Randel's DNA was found at Ultra's camp. Yes. So this is actually a bit aside here. Does the evidence prove? Let me just copy this so I can just edit it. Does the evidence prove that Mike Randel was involved with premeditation or premeditated murder beyond a reasonable doubt? So now we can bring these things back in. Right? We'll put them under because we already read it. So, premeditative murder. Let's go and look at murder. Let's go look at murder. Let's make sure I'm viewing this. Oh, I can't actually, like, click it. Cool. Anyway, murder. Find murder, please. There it is. First-degree murder, second-degree murder, manslaughter, and word I can't say, homicide. So, first-degree murder. An individual acted with the intent to kill or cause bodily harm, knowing it would likely result in death with premeditation. Let's define premeditation first. the act of planning something, especially a crime, beforehand. There is nothing to prove that what he did at the bank was premeditated. We don't have any evidence to prove that. Okay? Here's what we do have to prove, though. Here's what we do have to prove. This thing here, the list of public officials. Do we have a better thing? Yep, they're right there. This here proves that he premeditated, had the intent to take out the 2 mayor candidates, which I would argue our list of all political officials. I would list candidates as officials, okay? Because when you run for president, I know it's not as serious as president because it's a mayor, but when you run for president, just because you ran, I'm pretty sure you get Secret Service on you. Like when you're running, right? So in that mind, I would list them as political official. Okay, that is what I'm ruling here. So a list of all public officials. So I'm getting sidetracked here. So did he premeditatively kidnap the 2 mayor candidates with all the information we have? Yes. Yes. If he has a list, yes, he does. Yes, or well, he planned to kidnap 2 mayoral candidates. Sure. Candidates. There we go. He planned to kidnap 2 mayoral candidates. Okay? One of them was tortured. And I mean shit. Like, what the fuck would you call that? Like, he was tortured. He's on the ground completely fucked, right? So, would torturing mean intent to kill? Well, no, because he didn't die. He was alone with him. Right? We don't have anything on torture. We know he did kidnapping. Like, that's for sure. And we know that the mayor was tortured, for sure. But we don't have anything on actual torture. Because it's against the rules. That's probably why. Alright. So, there is nothing. There's nothing on torture. It's supposed to be against the rules. Like, you could probably call it, like, assault. But that's not class 1. Should first-degree murder not need someone to be dead? Maybe that's interpretation. An individual who acted with the intent to kill or to cause bodily harm knowing it would likely... Well, yeah. I guess you're right, Sam. Because if you torture someone within the inch of their life, that would likely result in death. I guess maybe we didn't clarify it enough, but if you phrase that the right way in your brain, it makes sense because you're reading an individual who acted with the intent to kill. No. Like, that doesn't cover it. That doesn't cover it at all. But it also states, or to cause bodily harm, knowing it would likely result in death with premeditation. He premeditatively wanted to capture him. And he did cause him bodily harm that could and would likely result in death. Okay? Because, look. He has a fucking saw in his chest. There's a saw supposed to be sticking out of him. Like he's fucked. No, I agree. I'm saying the law should require someone to die. Oh. Yeah, in this case it doesn't. Bam, loophole. That's also really nice UI. I like that. I like this minimalist stuff. I might even remove my background if that's an option. Anyway, so yeah. Interesting. Yeah, it would have been first degree murder, because what else would you do that with? Like, would you have a specific law for torture? Because, like, he did do bodily harm that could cause the thing. Like, per this, like, it's good. So let's look at that. He planned to kidnap 2 mayoral candidates. One of them was tortured. So, I believe that this is covered by first degree murder per the phrasing of, quote, copy this. Roboto. Ariel, please. 9, please. Oh, it's 11. My bad. And then we'll do italics because I love italics when coding stuff. Oh, and also the text is too light. There we go. I'm sure it's fine. Should be a law against torture. Yeah, I think the only reason why I wasn't even thinking about it is because I'm pretty sure torture RP is against server rules. Because I remember doing it and then a rule came in place. Because we were torturing someone's character. Man, it still looks weird. Okay. Hey. Shit. Okay. So, we proved that he was involved with bomb making. Proven. Beyond a reasonable doubt. Yep. He was making bombs. He blew one up. Act of terrorism now. The big question. Peels fingernails back. Gross. Really gross. So terrorism. Let's go down to terrorism. This is the big question. It's both of these. Okay? Creation of a mass destruction event. Or sorry, creation of mass destruction by means of explosive device or mass shooting in highly populated buildings. Now, here's the thing. We haven't really had an opinion, and maybe this is what happens, but we really haven't had an opinion on whether 30 people in a building is considered a highly populated building in our server. Because in real life, I'm imagining like that's 100 people, 50 people. But in the video game, where our game is like scaled down, right? Like, what does that mean? Okay? What does that mean? But maybe we don't have to specifically attack that yet. So, in highly populated buildings, structures, vehicles, or areas to influence and assert a political thing. Something I will note on the vehicles front. Let's find that. We know that Big Rick Army is Mike Randel. He sent in this tweet where all these things were blown up. I would say it's a highly populated vehicle area. Look how many fucking vehicles there are. And he said he blew those up. So if we really need it, we can use this too. To find out if he's right or wrong. Because really all we're trying to prove is beyond a reasonable doubt, right? So, we need to look at active terrorism. And highly populated buildings, structures, or vehicles, or areas to influence and assert a political or ideological change, instilling control or fear in the public. Shooting 3 people in the town hall seems to me like something where you're trying to assert something. Okay? You don't shoot up the town hall if you're not trying to assert something. Right? You don't. You really don't. Am I still getting paid? Fuck, it better be. I'm working hard. Because, like, Why else would you do it? Like, maybe I'm attacking this too aggressively here. But he killed 3 people here. And I was in the front. There were shell casings there, cigar butts, DNA. We can prove them to it. We can tie them to it. We can. He also said in the notes that we found on scene, or sorry, that was found. I need another bagel. That the place will be leveled soon. So he wants to blow up the building, right? So per the definition of planning an act of terrorism, I mean, if you say you're going to blow up the fucking building of the town hall where the mayor is and the judges are, I would consider that an act of terrorism. Or planning one for certain. Based off this thing over here. Right? I would say that that's planning one. Planning an act of terrorism. He said he's going to blow up the building, basically. Leveled, like, you know. I mean, look at your screen, Sam. This place will be leveled soon. In theory, he could talk about construction. Would you say that and make that argument against someone who left this note here among 3 dead bodies who are people who were dead? Because he didn't make that argument. He didn't say when we're discovery. He didn't say, well, that could be interpreted as what, right? This is him saying this place will be leveled soon. But when was that posted? What do you mean? It was posted directly at the shooting. Right? So directly at the shooting, when people came on scene, that was there. So maybe an argument could saying, hey, like maybe this was here beforehand, right? But something would tell me that in the real world, if someone left that there, that it would have been found immediately. But could have it been posted well before? I don't know. I don't know for a fact. I don't know for a fact. But I do know that Big Rick Army is him. I do know that. So, voice crack. So, see, the thing is I don't think the verbiage here really helps him very much. In my opinion. That's all I'm saying. Like, I don't think the verbiage helps. Of the word level. Okay? Because all this person's been doing on their Twitter is posting crazy shit. Right? Like, posting crazy shit. And it meets the MO. The MO is that he leaves post-it notes. Right? So there's there. That's a post-it note on this scene that his DNA was found. That's one instance, okay? Right here, post-it note. 2 instances. 3 instances. DNA was found on scene. 4 instances. There's 4 instances of him having an MO of leaving notes on scene. Now, what they should have done is compared handwriting. I think that would have helped. But let's look at active terrorism again. Because this one is still up in the air, right? I think that the notes, the MO of the note, leaving the notes, is more than enough. Because there's 4 instances of it. And in 3 of them, his DNA was not found on scene. Okay? So, I think, based off of that, and based off his verbiage, even though it says leveled, that he is planning an act of terrorism. Let's note it. Sorry, of the subject's actions with leaving notes on scene after the bombing of the bank, the shooting at the courthouse, and what else? And on the scenes of an officer down, plus at the altruist or nudist camp. The note found at the courthouse is clear evidence beyond a reasonable doubt that it was planning an act of terror. I might attack them. Because can you say beyond a reasonable doubt if he's not specifically using the verbiage of I'm gonna blow this place up? But is that a reasonable doubt? Like, is that reasonable to state that? Because, like, per what everything he said off of Twitter, like everything was being spelt wrong. Like it would make sense for him to acronize that or use a different word. Right. So, ladies and gentlemen, it's all come down to this. With everything we have understood, every bit of information we have gathered, is Mike Randel a terrorist? A terrorist. The verbatim thing is this. Creation of a mass destruction by means of explosive device or mass shooting in highly populated buildings, structures, vehicles, or areas to influence and assert a political or ideological change, instilling control or fear in the public. With that, I will bring you to his statement. On scene. Oops, not that far.
Uses the microphone when you speak.
Do
Okay.
this in any situation, then.
You're a lawyer, duh.
This is just argument. So
When you put the lives of people in the city in jeopardy,
I've already
you have
listened
to
to this.
remember I am a public defender. I work for the state, meaning I work for the government. It is my duty to put them first.
Are you objecting to anything else, Mr. Randall?
I object. He can do this in any situation, then. How are you supposed to trust your attorney if they're just going to turn your back on you? This is the BS my organization's trying to fight for.
Hang on. This is the BS my organization is trying to fight for. Was this said under oath? Is this admissible? Is this admissible? Sam, can I use this? He said it from his seat. It was a statement. Can I use it against him? Because I don't know. He said it in a court during an objection. What's your question? The DA stated he was guilty in an objection. I feel like that's a bad thing because it's very specific. Because it's speaking to two things, not just the if what someone says is admissible or not. Because like, if you say if he says he's guilty and that's admissible, like that's well in the case of a jury, I guess. Not, right? It probably wouldn't be. But the thing is I'm not sure. I'm not sure. Because in my mind, right, like, that could be misleading a jury in a jury trial, right? Yeah, research time. Let's go and have a look. So, USA, start there. Is what a defendant says in court while not on the stand admissible? Conditional admissibility. So omission by silence. What's this? Ah, that's not it. That's the right. Admissible evidence. Let's look at this. Admissible evidence is evidence that may be presented before the trier of fact, the judge or jury, for them to consider in deciding the case. Compare admissible and inadmissible evidence. Let's look at inadmissible. Inadmissible evidence is evidence that may not be introduced to a fact finder to prove the party's claim. The federal rules of evidence. Early stream, yeah. Good morning, Zook. Hope you're doing well. And I'm not showing this on stream for a reason, by the way. The federal rules of evidence, which apply to all civil and criminal federal court proceedings, govern whether evidence is inadmissible. If the evidence does not meet the standards of relevance, the privilege or public policy exists, the qualification of a witness or the authentication of evidence is at issue, or the evidence is unlawfully gathered, then it's inadmissible. But these rules, except for those on privilege, do not apply to the trial judge's determination on preliminary question of the fact governing admissibility. Man, this is a lot of legal jargon. Or smart person talk. Relevant evidence is probative and material evidence. It tends to make a fact more or less probable than it would be, or is a crucial fact in determining the action. Generally, if the evidence is irrelevant, then it is inadmissible. This evidence wasn't submitted. He literally just said it in court, which proves to the fact that he was acting on this. Right? He wasn't under oath. Oh my, this is just so much. Hearsay is an out-of-court statement that the declarant made to prove the truth of the matter inserted. It was in court. It was in court. Okay, let's look at admissible. Fuck. This legal system. So hard. I don't think it's an issue to use it. I mean, I think, like, my whole argument of giving him terrorists or not completely relies on what he just said. Right? Because without this, it becomes increasingly harder to prove beyond a reasonable doubt that he was trying to assert a political or ideological change. Okay? But I can say that he was planning it because there was a list of government officials. Right? That's why I'm allowing to say that I agree with planning, because there was a list of government officials and he had bomb making stuff. Okay? Which means he was planning a mass shooting, or he was planning to take out a bunch of fucking politicians, which some people would consider terrorism. Because, you know, like, you don't do that without instilling control or fear into the public. Okay, I'm just trying to find a better way to research this. Is what? Dude, what the fuck? Oh, something's fucked up. That was weird. Why was it doing that? Is what a defendant says in court admissible. When they're not on the stand is basically what I want. My brain hurts. Yeah, because I don't know how to research this. Yeah, I got no idea. Sam, I'm relying on you. I got nothing. Because this is my last question, right? Well, second last. I gotta see if I agree with, you know, what the district attorney is saying. Or if I have my own opinion. Legal research is tough, yeah. Yeah, it is. You know, I wonder if it would be useful if DOJ had their own radio channel. I mean, I'm pretty sure since we have access to the MBT, we can actually join their radio. Oh, no, never mind. I wonder, since we have access to the MBT, could we join it from the MBT? No, we don't come up as active units. Sedge. But you can lock that? Oh. Closed. Please come back. Okay. Okay. What is that? I mean, I'm going to explore the whole fucking thing anyway, so I'm probably gonna find that. So don't call me on metagaming. I was literally just, I literally just wanted to walk around and look around for a bit. I wanted to go in this big meeting room. Okay. I can't open this. Wow. Wow. I guess I'm fucked then. Let's go ahead and change my outfit. Go for a little drive. I need to get a work truck. Okay. Oh, I didn't change anything with that one. Oh, it's just bugged. Wow. That, or I didn't fucking save it properly. Yeah, of course. That's very, very frustrating. I want my outfits to be working when I need them. Please, and thank you. Okay, I'll change legs. I'm too far. I missed it. Dude, where is it? The fuck? Am I just blind? I mean, I know I'm going through a lot of stuff right now, but... Yeah, I was just blind. Okay. Black boots. Black gloves, please. Go. Right with the hat. I'll keep the mask in this outfit. Okay. Save current outfit to... Alright. And mask. I mean, I probably should have a bag, but... I mean, it's fucking midnight. Who's gonna see me? I'll change your walk style. Just because my walk style is actually fake. Like, it's an act. Quickly draw my farm. So I can defend myself if need be. I'm gonna go grab the truck because my Tahoe is a red herring. Move. Alright. Tahoe's always been a red herring. I love this truck. It just meets my needs. Arrest me for speeding? I've done so much worse than that. I just want to see if there's any service vehicles here so I can have more cover. Because since my hair is a wig, I could really get creative with some of this shit. So... No. No. I need a fucking... I know exactly what I need, and I don't think it's here. There's not gonna be imports. I know that shit. Well, one of them's there. 40 grand for it, Jesus. Not enough. I'll have to check the other dealership. Boop boop. It's not gonna be muscle. Yeah. Not here. Go on to Mosley's. I'd love to be able to own a dump truck. Tax ain't bad. Yeah, sometimes I forget this thing's here. Garage. Ooh. That's good. That's good. I DM'd you? Yeah, I'll bring it in a second. I just want to look at this van. Where's it bring me? It ends in 60 seconds, well I fucking better move then. Wait, do I not have this? I do have this. There are no liveries. Oh, fuck. Oh, never mind. The statement made by Randel was entirely voluntary. While it was not under oath, nor any evidence presented to back that claim, it probably should not be taken as evidence, but closer to a statement made by a witness. As such, I think it's fair to use it in your deliberation, but it alone should not be a reason behind your conviction. This should follow similarly to a standard confession. which on its own does not provide enough to convict the defendant, but may be used in addition to other evidence. In short, it can be used, but that alone should not be the only thing to provide something. Cool. Thank you, Sam. Appreciate you. So then to that, the thing is that's just it's verbiage proving that he's in an organization, but that's the only thing that proves he's in an organization, right? Like, that is the only thing. Not legal advice, Lamau. Yeah, like, that is the only thing that proves that he's in an organization. Which goes to the point, and let me get a little bit deeper underground. Where are you bringing me? I don't even know where that shit's bringing me. I want to get to the tunnels. Creation of a mass destruction event, or mass destruction by means of explosive device, or mass shooting in highly populated structures, buildings, or vehicles to influence and assert, or areas to influence and assert on a political or ideological change. Yeah, I don't know. This one's up in the air. This one's up in the air for me. Oh my fucking god. Hey, we didn't lose anything. We're good. Okay, that is good to know that that is very, touchy. Like, don't drive faster here. Good to know. Where does this take me? I know where that takes me. Does this come out? Jesus. Man, I don't have any fucking traction at all. I was trying to fucking pull off for a second. Where the hell does this come out to? Because this would be useful. Break it down to several points, find out what needs to be done for the charge, and try to prove each point specifically. We may be able to do that. Dude, I need a hobo outfit. Wow, there's fucking vending machines there. Wait, is there no locks? Oh, there is. Fuck. Dude, if there's a fucking subway without these, bruh, I'm gonna get one of those small ass cars and fucking yeet it down here. This isn't Rockford Plaza exit, is it? Holy shit, it is! What? Dude, this is like my main one. This is like Verdin's favorite area. Dick. Okay. So if I were to break it down into several points. That truck's on my left. If I were to break it down in several points. I don't know. I mean, I think there's no question that this is murder. Like, there's not even a shadow of a doubt. Like, there's nothing. Like, I am so sure that he committed those murders. I'm not sure if it was terrorism, or if it could be phrased as terrorism. Man, this fucking vehicle take a beating, huh? Might be a little bit easier driving these ones. Well, judging from what you're saying, it seems like you have some sort of reasonable doubt for terrorism. Yeah, yeah, there is some sort of reasonable doubt. I'm just trying to see if there is, because like I don't know if I'm thinking about it. But maybe I just fucking full sentence, just say no terrorism. Because, like, I'm personally doubtful of the situation here. Jesus. If I ever want to murder someone, I know where to go. Yeah, I will be murdering someone down here if I need to. Anyway, sorry. I'm getting sidetracked with being rotten. But yeah, I would say, yeah, like, with that, there is a reasonable doubt there. What kind of judge is this? Listen, the less you know, the better. The less you know, the better, Sam. Are these stairs done? Oh, nice. They're not textured. Well, they kind of are. Half-assed. Nice. Ooh. I wonder if you could get in there. Like, could you fucking jump in there and get yourself stuck? I bet you could. So yeah, I think there is a reasonable doubt for terrorism. He made bombs, right? But like per our definition, I'm gonna keep running, but I'll read. Per our definition, it says mass destruction event by means of explosive device. I don't think that him planting a bomb at the bank is a mass destruction event, right? Like, it is a destruction event, and it could have caused more shit, but there wasn't really much damage, right? Mass shooting. Like, is killing 3 people a mass shooting? I don't know. I don't know. I don't have any concern with planning the act of terrorism, though, because of the list. So, yeah, we're going to go ahead and strike this. There is a shadow of a doubt. Okay. I think we've made our decision. So now what we can do is since we've made our decision, we can go back. We can go back to the Dimitri thing. Yeah, that's not technically terrorism. Yeah, if you read the thing, like, is that really a mass destruction event? He blew up 2 cars. And also, that wasn't even brought up very much during the case. It was like 2 pictures. He blew up 2 cars. There is a shadow of a doubt. Creation of a mass destruction event, creation of mass destruction, which means a lot, right? Let me get back to the courthouse. Like, that means a lot, big numbers, big amount. By means of explosive device or mass shooting in highly populated buildings, structures, vehicles, or areas to assert a political or ideological change in instilling control or fear in the public. Like, you could argue, sure, Hey, Kenneth, that's not in our law book, buddy. If it's not in our law book, you can't use it. Yeah, it doesn't matter. It's not in our law book. Law book takes paramount over everything. And per our definition, which is right here. Right here. Creation of mass destruction by means of explosive device or mass shooting in highly populated buildings, structures, vehicles, or areas to influence and assert a political or ideological change, instilling control or fear in the public. You could probably state that he was trying to put fear in, but there's still a shadow of a doubt. There's still a shadow of a doubt. I feel terrorized. There's still a shadow of a doubt. All right, let me. I'm just walking around in the courthouse room. All right, so let's actually look at this. So I'm in my chair again. So the thing is that did he commit first-degree murder? Yes. In all degrees. There's like 7 first-degree murders. Did he plan an act of terrorism? Yes. Yes, planning an act of terrorism. Did he commit an act of terrorism? Per this definition, no. No. And also, during everything that was said, it wasn't specifically highlighted, as well as it probably should have been, how important to the case targeting public officials, both in politics and the chief of police, as well as judges and the district attorney and me, like, that wasn't really stated a lot. I don't think it was stated at all, because I didn't even highlight it as something important. Like, I watched the whole thing, and I didn't even mention it. I mentioned it at the end, where he had a list of public officials, right? So, let's read the definition together, just so we're clear, Kenneth. Creation of mass destruction by means of explosive device or mass shooting in highly populated buildings, structures, vehicles, or areas to influence and assert political and ideological change, instilling control or fear into the public. There wasn't enough information by the district attorney's office to state specifically that he was running for office. He was a part of an organization. He was all this shit, right? That wasn't brought up in court at all. Okay? Also, he blew up the bank. I wouldn't clarify that as mass destruction. He did use an explosive device, but I wouldn't class that as mass destruction. He doesn't have to do any of that for being politically motivated. It wasn't proved in court. It doesn't matter. No one said shit in court. It wasn't said at all. So the point of it being politically motivated or not is completely irrelevant, because the only thing he said in court isn't really even like useful. Right? So, like, you could be upset about this all you want, but the thing is like, it probably should have been brought up in court if you think it was that important. Okay, was that brought up in court, Kenneth? Like, obviously you can infer that he was targeting public officials with this thing right here, right? Like, obviously that. But that is him planning it. Right? And at this scene, he had taken someone in. Right? But nothing states in the court case that it was politically motivated. So he can target them, which he was, but like nothing in the case brought up that it was politically motivated to state that there is without a shadow of a doubt. Okay? Because you need to remember that I need to prove without a shadow of a doubt. Like a shadow of a doubt. Like it can't even be around the corner. Like it needs to be down the fucking street 2 blocks away. There is a shadow of a doubt. It's all in evidence. It's all in evidence. Well, he kidnapped somebody? Sure. Can't read that. Can't read that. 2 cars were blown up. Great. He killed somebody. Great. He blew up the bank. Great. Killed a bunch of people. Implied that he was going to blow this up, but that's still not enough. Because we don't know when this was put up. Great. List of public officials. Bomb making plans. Bomb. Planning an act of terrorism. Yes. Without a shadow of a doubt. Yes. Torture. Yes. Not against the law, technically. Same MO with the note thing. And also, by the way, this note, I misspoke on what I was saying. This note implies he was planning an act of terrorism because of the MO of him leaving notes everywhere. Okay? So this isn't an act of terrorism in itself because he didn't act on it. Alright? So we look at this. We know who he is. We looked at the narrative. We read all this shit. Right? We read all this shit. So let's read it again. Because we this is a part of the thing. But it isn't a signed affidavit. This is just a report. I don't know how much, how much weight this really should be holding. Okay. Telling him thing. Shot a cop. Yep. Uh-huh. But I don't know how much weight this really holds. Because it's not a signed affidavit. Our law book needs a definition of terrorism change? No. Our lawyers and prosecutors should become better prepared with the definition we have. Instead of making it, changing it to meet people's needs. That's all I'm saying. Like, making explosives probably should be against the law. If it's not. Okay, IED. Not financially motivated. Yep. And this is inadmissible. Can't use that yet. And then they have a conclusion. Mike Randall's politically motivated. I read this and I still don't know how they came to that. Reminds me of Monty Python. We found a witch, maybe burn her. Radical domestic terrorism. He posed a great and immediate threat. I mean, yeah. I don't see how this is telling us that he's politically motivated. Because it wasn't brought up in the thing of how important this was. It's all in the evidence. I don't care. It needs to be brought up in court. It needs to be specifically aimed by the district attorney saying, hey, this shows that he is politically motivated because he's working for this organization, or he's planning to run for mayor, or he's doing this. It wasn't brought up. That's the whole point of exhibits, is you're proving them in court. Right? It's not enough to say it's it's in the evidence here, because everything I'm looking at doesn't even prove that. Nothing here says that he's running for office. Nothing says he's a part of the of an organization. Like, he said it in court, but there's still a shadow of a doubt. Like, there's still a shadow of a doubt here. Like, that's the thing we're working with. I think you're misunderstanding me here. Is it needs to be super fucking clear. It needs to be so clear. You could see through it, like, through 80 mirrors. You could put it through, like, a void of mirrors, and you could still see through it. That's how clear it needs to be. There cannot be a shadow of a doubt. Right? So now, our decision has been made. Okay, let's make sure we got this in writing. Let's make sure we have this in writing. So, copy this. Paste it. The DOJ agrees with epilepsy. Epilepsy? I think the evidence from Kenneth may point to it, but we will see. Well, yeah, but then what we're doing now is we're writing out what I believe. We'll watch Kenneth's evidence, like his statement, and we'll decide, or I'll decide, if it's admissible. If it is, we'll use it. If it's not, we won't. Okay? Because I need to watch it and, like, actually consider it against the stuff I now know about crime, fraud, and other shit. So, in the case of 5 times first-degree murder, we find the defendant guilty. In the case of 4 times aggravated assault, that hasn't come up at all, but I'm assuming they are, like, are they tacking that on? I'm not sure about this. We might have to look back at that. In the case of act of terrorism, we find the defendant not guilty. In the case of planning an act of terrorism, we find the defendant guilty. Hello, Mason. Good morning. Welcome. Welcome to the chaos. So, that is our stuff. The fines and stuff, like, that's all semantics. Like, that shit is fine. Regardless of what Kenneth says, that's not going to affect my numbers. I need to use the bathroom. Give me a second. All right. Okay. So I want to talk about the aggravated assault because I didn't even bring that up. Why is there 4 aggravated assaults on this? Why is there... I mean, he's not going to be able to pay it anyway, Adam. Like, the state's going to get his money first, and that's just going to be his whole bank account. So, why is there 4 aggravated assaults? Like, was that brought up? At all? But also make sure of the murder counts. I mean, I'm pretty sure it's actually more murder counts. So, like, let's count real quick. So there should be 3 people here. They didn't take a picture of it, though. Because there's supposed to be 3. There's 3 clerks here. There's 1, 2, and there's a judge dude right behind him. But it wasn't included, so maybe we don't count it then. So 1, 2. Right? 1, 2. Let's go to here. Go to the bank. That would be aggravated assault. So we're at 2. That's 3. That's 4. That's 5. And that's 6. That's 6. Right there. So 1, 2, 3, 4. And then we have 5, 6 from the court. Okay? So it's actually 6. There's 6 bodies in here. Right? There's 6 bodies here. So I don't know how they got 5. Okay? So aggravated assault. So we have, let's see. 1 count right there. We have 1 count of kidnapping. So 1 count of aggravated assault, 1 count of kidnapping. Two counts of aggravated assault. 2 counts of kidnapping because he was kidnapped. I mean, that's it. How did we get 4? Where's the other 2? Where's the other 2? Neutralize the threat. I mean, you could call that assault, right? Forcing someone to do something against their will, you could call that assault. It was stated there was 4 cops down in the hospital scene. You're right. So technically it would be 5 then. Because of this. Well, no, technically it would be 6, right? Because that's aggravated assault against the judge. Because he didn't die. And this is aggravated assault. Because of the thing. So that's this cop here that was at the courthouse scene. There's the mayor, and then if he's going off because we don't know the names, he's giving them that, then that would make sense. Because we know that May and McDougan were both downed on scene. So that would be 3 counts of aggravated assault versus law enforcement, and 1 count against civilian. So, 4 counts of ag assault, 3 being against Leo, 1 being against civilian. Obviously, we don't count locals. Well, actually, technically, we are counting locals. Because if we're not, he doesn't get any murder. Right? Because who did he murder if there's locals? Think about that. For murder, I would. Well, murder's the heaviest charge in the server. I mean, obviously you wouldn't do aggravated assault, but he didn't assault anybody anyway. For civilians. For locals. I think he only pursued the 4 aggravated assaults on ES, but he didn't give us names on that. And I can't, like, interpretation would be something else. But the thing is like, I will pursue murder here because it was a planned scene and, like, he actually wrote down that there was dead people there. Right? We have 3 names from the reports. It wasn't stated in court. Let's see. Where the fuck is Pillbox? I mean, there's nothing in here referencing Pillbox. And I know that Bobby Dean's report spoke about Pillbox. So what did he say? So he only said that May and McDougan were downed. Right? So here's what I'm considering aggravated assault, okay? So there's May and McDougan at Pillbox. Alright? There's the mayor at the nudist camp, so that's 3. Right? And then there's an officer here. Here. That I'm also considering as evidence. Okay? Because this was, I'm pretty sure this was Jardine, but, you know. But this is the same MO. Okay? Even though there wasn't very much written on it, same MO. So that would be 4. So is there actually 6 counts of murder then? Yes, there's 6. There's 4 at the explosion. There's 4 at the explosion at the bank, and there's 2 who were murdered at the courthouse. There should have been 3, but they didn't list it. All right. 3 against a civilian. 2 at Pillbox. 1 outside courthouse. And 1 at nudist camp. Right? Murder. 4 at bank. 2 at courthouse. Right? So, I mean, how much information was there to say that he shot these people, though? So I know for a fact, without a shadow of a doubt, that he was the one who did the mayor thing. Okay? Know that for a fact. Know it for a fact. So that's 1 for a fact. Number 2, the person here. It meets his MO, but I don't know it for a fact. I don't. There isn't enough information here. There wasn't enough said. Okay? For the May thing, I will take his testimony at face value here. I can't take it at a testimony at face value because he doesn't say it. He doesn't say it. He doesn't say it. And you can't specifically state, because, you know, there was a shootout, you can't specifically state that he's guilty of that because the definition of aggravated assault needs you to hit him, and there's also 2 people shooting, being Paula Randel and Mike Randel. So really, it's only 1 count of aggravated assault, and it's probably not even considered aggravated because of the definition of aggravated assault. So let's look. Let's look at the definition. Let's make sure we're clear here. This is where it gets very specific, ladies and gentlemen. We're good. We're good, never mind. For the mayor, for sure. Causing serious physical injury to another by force that may result in disfigurement, loss or impairment of any organs, or fractures in the commission of assault, which includes the use of deadly weapons or dangerous instrument. A saw is a dangerous instrument. We're good. So yeah, I can only say without a shadow of a doubt that he has committed 1 account. Mayoral candidate. Yeah, just correct that. Thank you. Candidate Harris. All right. In the case of 4 times aggravated assault, we find the defendant guilty. Oh, that's what you need to say. Guilty on all counts. Guilty on 1 count. We find the defendant guilty on 6 counts of murder in the first degree. He was involved in a shooting, so at a minimum on accessory. Semantics. Fucking accessory. Fucking accessory. Like, I don't think there was enough there. And regardless, like, do we really need to add that? Maybe. Like, sure. Like, yeah, I'll agree with you there. Guilty on 1 count and accessory to 2. 2. Well, I can't say accessory because I don't know if Paula Randel shot him. It wasn't brought up in court. Or it wasn't brought up to the extent that I would need to prove beyond a shadow of a doubt. I wouldn't add extra charges he wasn't pursuing, though, would you? I would. I would. Well, man, I'm trying to think about this. The thing is like, what the fuck happened? Like, did they miscount? Sam? Because there's 6 bodies on the ground. There's 6 bodies. There's 6 locals down. 2 at the courthouse, 4 at the bank. So let me just look at my document here. Let me see. Where's my cheat sheet? Judge stuff. Or the DA felt there wasn't enough evidence. I mean, I don't feel there was enough. I feel there was plenty for the locals. I mean, his DNA was found on scene. Shotgun shells with his fingerprints on it was found on scene at the bank. So this without a shadow of doubt. Okay? Without a shadow of doubt. The cigars and everything. And the bomb. And I already agreed that the bomb was his. That he made it. Because of all the evidence we talked about today. So, like, that's that. Right? So let me see. Where is my thing on this? Judge is an independent, impartial, a decision maker in the pursuit of justice. In the pursuit of justice. I mean, I think that covers it. Each side makes its arguments and presents the facts and evidence and that it wants the jury or the judge in our case to consider. The judge will oversee it without bias. The judge is the ruler of the courtroom. They decide all matter of courtroom procedures and also decide all legal issues, including the ruling out evidentiary objections, whether it's inadmissible and admissible. When the judge was, that we already spoke. I already know that. Trier of fact. If the judge finds the defendant liable, they must also decide how much the defendant must pay. There are cases where the jury is not permitted or the parties are weighed trial by jury. But the judge is also trier of fact. The judge decides both legal issues and factual issues. It can be streamlined. Jesus, there's so much stuff in this document. I mean, probably, right? I mean, that's the only things we're bringing. I don't know. In my mind, like, I don't know. I'm torn on this. Does it really make a difference? Probably not. Guilty on all counts. Because I can lower it, right? I know I can lower it. Because I only find him guilty on one count of aggravated assault. In the case of active terrorism, we find the defendant not guilty. In the case of planning an act of terrorism, we find the defendant guilty. Okay. James May. Lucille McDougan. And the officer who was downed. Not enough evidence presented to prove. All right. Justification. The list of names found at the nudist camp, along with the bomb making materials and bomb planning or plans. Making plans. I believe it's more than enough justification to state that the defendant was planning an act of terrorism. Oh, sorry. I got backwards in this. Justification. I believe there is a shadow of a doubt that the defendant did not commit an act of terrorism due to the evidence listed in this case. I mean, that's enough for me. That's enough for me. All right. Okay. Now we get into the controversial bit.
Under the Patriot Act, special privileges are granted in instances of domestic terrorism.
I could not read anything
waiving
about
of
this.
privilege qualifies.
I could not see
object to
anything about that.
statement.
It's gonna be overruled, unfortunately.
I won't be the first, and I definitely down with the system. That's all I gotta say.
Okay, we can move forward. Questions, Mr. Nyman.
Of course. Mr. Jones, what is your current occupation? Oh,
Public.
sorry. Actually, I believe you still need to be sworn in.
No, he was sworn in.
Okay. What is your current
Yeah.
occupation, Mr. Jones?
Public defender for this.
Not a good one.
Mr. Randel, please rephrase from making comments.
Refrain.
We want to have a fair court trial here, and you're really muddling the waters here. Thank you. Continue.
Could you describe your relationship with the defendant?
We were close. I knew a bit
Actually,
more
sorry.
about
Could we
what
get him a
you-
megaphone?
Does any officers in the courtroom have a megaphone? Yeah, come up. Well, we'll just leave it at the witness stand. Sorry, that's an oversight.
How do
Yeah, you just hold it.
Yeah.
This is where he dies.
Mr. Neiman, my occupation is public defender in the state of San Andreas, and to answer your other question, my relationship with Mr. Randall was close. I mean, we were close. I'd say we were friends. I knew a bit more about what he was into than I would have ever cared to know. I believe that's why I'm here today, because I did not feel comfortable knowing the lives of other individuals in our great city were in jeopardy.
And why don't you elaborate on that? What has brought you to waive your attorney-client privilege today? That's a pretty big thing.
It was brought to my attention he was involved with shootings going on outside the courthouse during a trial that I was representing, as well as some other information.
Do you mind elaborating on that further? More in detail, please.
You actually have to push the button that uses the microphone when you speak. They can't hear you back.
Mr. Jones?
Stand by. He's having problems.
Yeah, I know. I'm trying to.
Yeah, you
figure
gotta.
out.
So,
Believe.
Ask the question again, Mr. Nyman.
I believe.
Stand by. Ask the question again.
Sorry.
So, why don't you elaborate on that a bit further about what actually happened on the shooting at the courthouse?
I believe, if I remember correctly, he called me asking for legal advice as to what he should do if he had just.
Objection, Your Honor.
On what grounds?
Hearsay.
Your Honor, this is clear first-hand testimony. Mr. Jones witnessed and heard the conversation himself. This is not hearsay in any shape
How
or form.
can he confirm that conversation?
Jones, you're not actually using
It's a first-hand account, Your Honor.
Overruled. Please continue.
He called me asking for legal advice as to what he should do if
I'm
he had
active listening
just
right now, that's why I'm not
fired a
talking.
weapon outside the courthouse. To which I advised him to cease what he's doing and either turn himself in, or knowing the type of person he is and the things he's into, I knew that was not likely to happen, so I advised him to get out of the area and stop what he was doing completely. And leave the area, leave him alone. It's not worth getting into. It's going to get you in more trouble than you need. For legal advice.
Jones, you're not actually using
It's a first-hand account, Your Honor.
Overruled. I need to listen to this again. Please continue.
He called me asking for legal advice as to what he should do if he had just fired a weapon outside the courthouse, to which I advised him to.
Okay. All right. That is a crime fraud exemption. What he just stated I think it's crime fraud exemption. He asked for advice because he just committed a crime. Per crime fraud exemption, let's pull up my Discord where I wrote it. I just need to read what I said. The attorney-client privilege does not cover statements made by the client to their lawyer if the statements are meant to further or conceal a crime. For this exemption to apply, the client must be in the process of committing a crime, which he was, or planning to commit a crime. So that specific statement is covered by crime fraud because he was committing a crime and he asked advice on it. He wasn't trying to cover it up, though.
Asking for legal advice as to what he should do if he had just fired a weapon.
If he had just fired a weapon. Yeah, maybe that can't be considered a crime.
Outside the courthouse,
Let's
to
continue.
which I advised him to cease what he's doing and either turn himself in, or having my knowing the type of person he is and the things he's into, I knew that was not likely to happen, so I advised him to get out of the area and stop what he was doing completely. And leave the area, leave him alone. It's not worth getting into. It's going to get you in more trouble than you need.
So, but
Like,
that sounds like
just-
it's just standard an attorney advising a client. What brought you to break the privilege?
I believe it was brought to my intent. So I believe it was brought to my attention he was involved in other situations before that,
Could you be a bit
such
more
as
specific?
the
Hang on. It was brought to my attention? It was brought to my attention. Meaning not firsthand. If that's not clarified, that's going to be a big point in whether I take this off or not. Let me write that down. Hold on. Where's my note? Where's my note? Crime was brought to my attention that the client was doing by someone else, by a third party.
mayor being
That sounds like
just
it's
the type of person he is and the things he's into. I knew that was not likely to happen, so I advised him to get out of the area and stop what he was doing completely. And
That's not what you said in court, Kenneth.
leave the area,
You can't clarify it now.
leave him alone. It's not worth getting into. It's going to get you
It's everything. It was everything that was said in court. What you just said in my chat is not admissible, and I can't use it.
more trouble than you need.
so, but
Like,
that sounds like
just-
it's just standard an attorney advising a client. What brought you to break the privilege?
Oh, do you know what? We can actually use this now. Because we can actually look at it and read what the fuck it says. Okay, that's really nothing. Yeah, that literally does nothing, that evidence does. Like, that doesn't show the Twitter thing. Oh, fuck. Review. I did an offense. I need legal advice soon. There's nothing here. Yeah.
I believe it was brought to my intent. So I believe it was brought to my attention he was involved in other situations before that,
Could you be a bit
such
more
as
specific?
the mayor.
I know, but saying it was brought to my attention leaves it open and without having time to go over everything I had. Exactly. It leaves a shadow of a doubt.
being kidnapped and tortured, it was brought to my attention that he may have been involved in that.
It was brought to my attention that he may have been involved with that. Still not a reason to break privilege.
And I have
I'm sorry, I'm
some
actually gonna have the motion to strike that.
messages.
That is hearsay. Do
Granted.
you mind?
He's striking the thing about the mayor candidate, which is fine because he already said it was brought to my attention, crime was brought to my attention that a client was doing, and I am taking that it was by a third party, but that's not actually what it was.
Mind being more specific? What actually brought you specifically to break this here, aside from?
Okay, maybe this will clear it up.
I believe it was when he asked about bombing the courthouse while I was in here.
That when he asked about bombing the courthouse, okay? That wasn't present in any evidence and any exhibits that we have. Just as a note. And I would hope that it doesn't, Dimitri is not specifically referring to this thing right here. I really hope that that's not what he's saying. Okay? Needle, bomb, mind blown. Bomb, mind blown, needle. Like, what does that mean? Like, I'm not in his psyche. I can't speak to where his headspace is at, right?
Here while we were.
Let me go back.
The hearsay.
I believe it was when he asked about bombing the courthouse while I was in here, while we were holding a trial for another individual. He asked something about bombing the courthouse, and I believe that was when I knew he was much bigger of a threat than something I could ever morally represent in the courtroom, and that is when, under the Patriot Act,
Which is
I
out of your ass.
set
but,
attorney-client privilege aside and turned over my phone, including text messages on my phone.
Okay. Hello,
that I
Jack.
believe
Welcome.
McDougan saw as well to the police.
All right. So, to my understanding, he is allowed to tell police, hey, my client has just put in a bomb threat. Completely fine. He is not allowed to turn over his phone. No. Not allowed. That's all privileged. It's all privileged. Per that. You cannot break privilege when threats are made. You can tell officers saying, hey, he's making a threat. That's fine. That's fine. You can't break your whole privilege. It's not up to you. It's up to the client. So you can tell them about the threats. That's fine. You cannot turn over your phone because it has other privilege information that doesn't relate to stuff that he was actively doing. It was talking about past tense, right? It was talking about the past. So if he said, I shot this guy, right? That, it's already done. So that's still privileged information. So you can't show anybody the phone. But if it's a threat, an active threat, you can't. You can't. It's like the medical guys. If you tell the doc you want to hurt yourself, they'll report that. But they won't go saying you have 13 STDs because that's not allowed. Yeah, and they also won't report you just because you're doing drugs. Let's listen on. Let's go back.
Attorney-client privilege. I believe that was when, while we were holding a trial for another individual, he asked something about bombing the courthouse, and I believe that was when I knew he was much bigger of a threat than something I could.
He was a bigger threat than something I could morally, right?
ever morally represent in the courtroom, and that is when, under the
See, what should have happened here? What should have happened here is that the lawyer, Kenneth, or whoa, I can go all the way over here. No, I cannot go all the way over here. That's why it's a fucking page break. That makes sense. I forgot. So in the courtroom, morally represent him in the courtroom. So what should have happened? What should have happened is that you should have stopped representing him, and there is a word for that. I don't know it, but there's a thing where you stop representing him for whatever reason, perjury or something. I don't know. It's not perjury. I don't fucking know. But there's, like, you could have just stopped representing him right there because of moral objections. But that does, even if you're not representing him, even if he's dead, you still can never break attorney-client privilege.
Patriot Act, I set attorney-client privilege aside and
and under the Patriot Act, which is something I searched up and found nothing about anything about breaking attorney-client privilege. It's just about 2001, September 11th, and they're changing the way they handle terrorism. But there was nothing about attorney-client privilege, to be clear. I waived, and sorry, I got lost.
in the courtroom, and that is when, under the Patriot Act, I set attorney-client privilege aside and turned over my phone, including text messages on my phone that I believe McDougan saw as well, to the police.
Uh-oh. That's not good. If that's inadmissible, does everything that McDougan say is inadmissible as well? How far does this go? Is this mistrial a bull? Because it fucking could be. If that, it depends on when she saw it. Like, how much? Like, does that affect police? Does that affect their statements? Well, yeah, we'll listen on.
Did you think he would actually follow through?
It didn't matter to me whether I thought he would actually follow through. A threat's a threat. I have to treat every single one as if it's credible. Because if I don't think it's credible and it turns out to be credible, then I have to live with that for the rest of my life. He doesn't.
To your knowledge, did he follow through?
What's speculation?
On bombing the courthouse.
On bombing the courthouse, to your knowledge, did he follow through?
I don't think this is relevant to what I'm writing. Because I already
No, he
know.
did not.
I already know that him breaking attorney-client privilege to report an act of crime that's going to happen is fine. We're talking about the statement here.
Any of these other threats, did he follow through on?
Oh God, Sam,
The
this is gonna be a
others weren't
thing, man.
Threats. It was him calling me after he had done something, asking for legal advice.
This is gonna be a
And
thing.
why don't you elaborate? What were these things he did?
I'm sorry, my memory's a little fuzzy.
That's
Didn't
fine.
prep your
Did you
witness.
ever feel in danger
Should have prepped your
with
witness.
Mr. Randel?
Not relevant to
For
what I'm
my
writing.
personal life, I was the one willing to represent him.
I know nothing.
and
I see. Yeah.
This isn't meant to be degrading or as an insult, but he would have been dumb to do anything.
Oh,
When you were
my.
with Mr. Randel, did you ever feel anyone else could be in danger?
Still not relevant to what I'm doing.
While I was in his presence, no, because he knew. I make it publicly known to every single one of my clients. I don't want to see you commit any illegal acts.
Sorry,
And the less I know, the better.
there
I
wasn't
need
a
to know
question
the
for
fair.
that.
Yeah,
It's
I'm
not
gonna
relevant.
strike that. Please
Going-
only answer when you're being asked a question.
Going back to that shooting you described earlier, do you mind telling us what happened?
I was in here representing a client. I believe you were here as well. There's some shooting going on outside. The police ran outside, and something else happened. I ended up being injured. That's when our very generous judge here approved certain actions by both me and you while we're in the courthouse representing individuals.
Sorry, do you mind being a bit more specific by certain actions?
Honestly, right now I would focus on the statements he makes and either admitting them or not. The issue of him breaking privilege isn't one for this case. Yes and no. If he broke privilege and it wasn't justified, which is what I'm trying to find out now, right? Then that then I guess I could go statement per statement and see if they actually break privilege or not. But the thing is I don't know what was told in private. Like, I don't know what is under privilege or not. So, like, how can I state, like I know that the thing he just stated about, like, specifically about shooting, like, that's probably not privileged, but if he says that, oh, his client said this to him, then that's privileged, right? So, like, at that point, like, because it wasn't thinking about it, like, you just strike the whole thing, and then you either call a mistrial or just completely strike it, because it poisons the chalice, as they say. Because I can't like go one by one on each thing because I don't know what was said under client privilege.
I ended up being injured. That's when
Blood
there's
sugar
some
issues.
shooting going on outside. The police ran outside.
Admissible. It's all good.
And something else happened. I ended up being injured. That's when our very generous judge here approved certain actions by both me and you
Not relevant.
while we're in the courthouse representing individuals.
Sorry, do you mind being a bit more specific by certain actions?
He allowed us to.
Sorry, you cut off
Just
the
died.
Being
behavior of terrorists.
On my grounds.
Objection.
On my grounds.
What is the relevance? I'm not being charged with any shooting at the courthouse.
Your Honor, we're establishing a pattern of behavior of terroristic actions.
Not be proven.
Can you prove that he
We
was
have a-
involved?
We have a witness here to prove that, and another witness that can also back up his statements.
The statements, or that I actually shot?
McDougan.
Stand by one, please. I'm gonna sustain that objection.
Okay. No further questions at this time.
That was hot. Well,
What?
Are you okay, sir?
I wasn't paying attention.
Could you please sit him up? Could you...
Is he ready, or does he need to...
He's ready.
All right. So you described our relationship as a friendship. What makes you think we were friends?
Objection relevancy.
Well, you asked about us being friends, and I just want to...
You did ask about the
I asked about the relationship, which...
All right. I'll ask it a different way.
Go ahead.
If our relationship was friends, what actions did I do to make you think that?
It's actually less relevant, but fuck it.
So, the way you treated me, how open you were to me as your attorney, even after I had said
So what you're saying is
the
you were my
less I know,
attorney.
the better.
So what you're saying is
l-
you were my attorney.
Sir, if you let me.
I'm asking you a different question.
Please let him answer the question that you just asked him.
The way how open you were to me, even after I told you the less I know, the better. Shown to me you have a certain level of confidence and trust in me as you would a friend. So that showed me one of two things. Either you had a certain level of confidence and trust in me as you would a friend, or you're just a socio-psycho.
I had trust in you because you were my attorney. We are not friends.
Damn, he fucking.
After I
Sorry,
told you
Your
the
Honor,
less I
I'm gonna
know.
have to motion to strike the last. part
Yeah,
of Mr.
stop
Jones'
making
comment.
statements, Mr. Randall.
I had a
Yes.
question mark at the end of that statement.
No,
That's
sorry.
not-
My motion to strike was towards Mr. Jones, to the point of it was argumentative. That last portion.
You're saying the answer was argumentative?
The last part comparing him to a sociopath.
me
As far as I'm
calling
aware,
him
Mr.
a-
Jones is not a
yes,
licensed.
yes.
Yeah, are you a
psychiatrist.
medical professional, Mr. Jones? What's your role?
I strike that, of course.
That was a question.
I
Relevancy.
believe that was answered earlier. I am a public attorney.
That's
Alright.
answered.
And you said, so what made you feel like you shouldn't report the actions of myself or alleged actions up until this moment? Why did you keep that from law enforcement?
Oh, I didn't keep it from him. The moment you sent a picture of Chief Adkins' car to me outside the courthouse during a trial, that is when I thought to myself, hey, this is more than petty crime. This is acts of terrorism. And under the Patriot Act, our attorney-client privilege was set to the
Sending a picture of Atkins' car is an act of terrorism? There's no context here. There's no context.
side. And I showed the text messages to McDougan, as well as informed her of our conversation.
You didn't say that.
Patriot Act trial car
Let's
to
listen
me.
to it again.
The moment you sent a picture of Chief Adkins' car to me outside the courthouse during a trial, that is when I thought to myself, hey, this is more than petty crime. This is acts
Okay.
of terrorism. And under the
Sorry, I had headphones in. Hello, Kane. How are you?
No, you're good. You're good. I'm just doing a bit of paperwork stuff.
Oh, yeah, I'm currently deliberating a fucking case, I'll tell you that. Currently trying to decide whether attorney-client privilege is granted or not. We had a dude break it mid-court case. Well, not mid-court case, but he broke it.
That's
Dimitri.
not good.
Yeah, I don't know if you have any, like, crazy opinions on that. Kind of right in the middle of it, though, so I don't know if you want to talk or...
No,
Wait.
you're good. I'll let you finish. I'm sure we can talk afterwards.
Yep,
Was,
I'll be here.
was this you that split all the money into $1 bills in the stash? Oh my.
No, that wasn't me. That was someone else.
Alright,
put
well,
my
I'll let you
headphones
get back
back
to
in.
your deliberations. Yeah.
A little bit of mischief. A little bit of mischief. Okay.
Patriot Act,
All right.
a trial, that is when I thought to myself, hey, this is more than petty crime. This is acts of terrorism. And under the Patriot Act, our attorney-client privilege...
You didn't say that. You assumed it was in evidence. It wasn't. You didn't say it.
was set to the side, and I showed the text messages to McDougan, as well as informed her of our conversations.
Text messages wasn't
And I informed
really in
Chief
there.
Adkins as well, and showed him the text messages as well, along with the pictures of his car and a text saying, should I...
So, everything that was just said there was inadmissible. Everything there, inadmissible. Just clear, like, it's referencing evidence that's not submitted. The evidence are not in there. And I think it breaks, well, it probably doesn't break privilege because you were allowed to say it, and you probably were allowed to say it in court. It's just we don't have any evidence to back it up. Like, there's no anything. So yeah, I think what I am gonna do is I'm probably gonna strike your testimony.
What?
A text message saying, and I quote, "Should I do it?"
Like, that's fine. You can report that to police. Damn.
Should you do what?
And police can then report it to the district attorney, and then they can bring it up. But it wasn't. Okay.
So you continue. So you continued to let me think you were my lawyer the entire time.
No, I believe at
Objection
that time,
foundation.
I
That's
cut...
never been stated.
Sustained. Please keep it relevant to the questions that Mr. Nyman asked. Yeah, you can do redirect on that. You could recall
Alright.
the witness if you have specific questions.
Yeah,
recall.
all right, sounds good. No more questions, Your Honor.
Would you like to redirect, Mr. Nyman?
No, Your Honor. I'll move to my
Thank
next
you.
witness.
Alright, you can return your seat. Okay.
Thank you.
Alright, Kane. Are you mentally present?
What's up?
I said, are you mentally present?
I mean, kinda. I'm just kind of messing around with the MDT, trying to see things.
Okay. So can you take a seat because this is like a thing, and I need your opinion on it. So, I'm currently deciding whether a testimony is admissible or inadmissible after the fact, on the basis of attorney-client privilege. So basically, just a small rundown is the lawyer, the ex-lawyer of somebody, gave over their phone to police off the basis of that they were actively going to commit a crime, which is fine, but then they had a testimony about it in court, which in my mind is not fine.
They testified about a crime that...
No,
Someone
they
said they
testified
was
about
committed.
everything that the person said.
Oh.
Or a lot of things about what the person said. So what I'm considering is striking it and deleting it from my memory, because I've already like deliberated and stuff, and I already had my answer before it, and I didn't actually like really remember. But the thing is like there's grounds for mistrial here because he showed it to police, and like police had their own thing on it, and I don't know how many times they referenced it or not. So like I'm very concerned here. If you need more information, I can clarify it a bit more. It's kind of jumbled.
Yeah, so someone broke privilege, or you're
Yep.
saying they did, because they thought someone was going to commit a crime, which is fine, but then they testified past that on other things.
Yes.
And you're thinking the police took that and testified in regards to that.
And possibly use that to benefit their testimony.
I mean, in theory, yes, there definitely is the possibility of a mistrial. It all depends on what kind of what the testimony from the officers was. Like, if it referenced any information provided by that, it can't be used.
Yeah, it could be inadmissible. And I'm pretty sure, like, I wrote what was relevant to what the testimony was. And specifically, they listed as Corporal McDougan was the one who saw the text messages. And what she said, if I can find it. So she was the lead detective, like, she was informed about, like, the kidnapping and stuff. She informed other people's about it. But I'm pretty sure she found out the person's Twitter. Like, it could have been, like, helped with that. Like, there's a lot of, like, little things here that, like...
So, the kidnapping would be fine if she found out from that, because that's a potential crime or whatever.
Yep.
The Twitter... do you know, like, if that, like, do you know if she did find out that Twitter because of him, or?
I don't. I'm saying, like, that could have been, like, the only thing here that is a possibility. But also, there are other pieces of evidence that would prove that it was his Twitter anyway. So there's 4 notes involved, which is giving him an MO of leaving notes on scene. And one of those notes left on the scene at the courthouse was referencing his Twitter, and his DNA was found on scene. And pictures of him on that was found on that Twitter that matches his mugshot. So, like, we can prove that the Twitter was his with every bit of evidence we have that doesn't apply to the lawyer's testimony.
Well, if that's like,
It feels like to me that it poisoned the well, or muddied the chalice, or muddied the waters, whatever fucking terminology you want to use. Because, like, at first, like, I was just going with the flow that the district attorney was not speaking from his ass, and the Patriot Act actually had a statute that said you can go against privilege, like, in totality. But doing more research, and that's why I'm glad I'm deliberating after the fact, but doing more research, that's not true. Like, there's a crime fraud exemption, but that only speaks to the fact that he was allowed to tell police that there was a crime going to be committed.
yeah, the DA likes to talk out of his ass a lot. You gotta watch out for it. I've seen it a few times. There's a lot of his objections and stuff that's just complete bullshit, but he speaks well and it works for him, so I gotta give him that.
Mm-hmm.
I can't lie. But
I mean, I speak out of my ass, too.
So, if you feel that the that any of the testimony or any of the evidence that was crucial to the case was in connection or received or whatever you want to say in connection to the information that was broken through privilege, then yes, you would probably need a mistrial. If you think that there's enough information outside of that, or that the information provided wasn't in reference to that or whatever, you could probably get away with striking the, or not considering the information provided through that, and
I think
making a determination through it.
I think with everything I've learned about this case and everything I deliberated for the last 3 hours about this case, is that without his testimony, it literally changes nothing. And there's 3 pictures which was listed in evidence, which are from his phone, that would have had to be striked. But I don't think that they were referenced, and I don't think they really much matter, other than showing, like, an intent to do something, but already have gotten intent for him to do something. So, like, it doesn't really affect anything.
Yeah,
it does affect a lawyer, because breaking privilege is a thing that we've never dealt with.
Yeah, that'll be something that needs to be handled outside of this.
But
if you think that there's enough evidence outside of what was said, like if you think that if the lawyer didn't break privilege, your decision would still stand, then go for it. I don't think there'll be an issue there, as long as you are confident in that, though. Because, and you got to make that decision, because in all honesty, if you go for a mistrial, like, because at that point, still, what else provided to that cop was said? What, can you now take anything that cop says and all that jazz, especially if you said, what, she was one of the detectives on scene?
Lead,
yeah. So that becomes a huge issue, right? If you feel that severely affected any of the testimony or anything, it becomes a massive issue.
Yeah, everything I wrote...
In all honesty, the case probably would end up just getting tossed, not even a mistrial.
Yeah, everything I wrote with the statements on stuff that was relevant to the case, it doesn't show me as anything that she stated was completely affected and based off of the testimony, or sorry, the breaking of privilege in private to the officer affected it. The only thing that, like, had changed was, like, they knew where to get the person.
So,
because, like, they knew, like, that they were being kidnapped, or someone else was being kidnapped at the nudist camp.
What all did whoever the lawyer was, like, say to the officer? Like, did they speak with them? Did they just
They said that they showed the officer text messages,
They showed officer text messages.
and those text messages are referencing. It was a picture of the chief's car, and then there was like a bomb emoji or set like the testimony led me to believe that the the defendant said verbatim, like I'm going to bomb this car, but the dude was using a lot of emojis, so I don't have evidence on that, so I can't.
Well, the other thing you could always do is call Miss McDougan into here, swear her in, and have her say, like, hey, what all did you get from this? Where did you get the rest of your information from, and all that jazz, and figure out what exactly was taken from that privileged information.
I mean,
and
that's a
what
good
wasn't.
that's a good decision. Like, I could do that.
That's probably the best bet, just to clear up any confusion. Right? So, like, hey, how'd you figure out this? Was it from this, or was it from your own information? And let's go from there.
Hmm. And I think at the end of the day, I think where I'm leaning is just striking what he said from the record. Striking the evidence and happy with my current thing, because right now where I'm at with this case, because I wrote it before I reviewed this so I can stay unbiased,
I gotcha.
was I'm at five first degree murder charges, one count of aggravated assault, not guilty on act of terrorism, and guilty on planning an act of terrorism. So yeah, big case, by the way.
What the hell did this guy do? Holy.
Yeah.
All right.
So so what he did was he planted, well, I don't know if he planted, but he was involved with having a bomb set in one of the banks, one of the Fleeca banks, and it killed 4 people. And then he also shot up the courthouse, or he shot up our clerks, I mean. So that's another 2 murders, and his DNA was found all over the scenes and left notes. So,
Okay.
I haven't even thought about like what kind of fines or shit he got. Like, the district attorney wants death, but I don't know if I'm gonna grant that. I'm more of a supporter of let him rot in prison myself.
That's fair enough. It still messes with my sleep. I hated it.
Yeah. I'd rather not.
Yeah, I don't blame you for that. But yeah, like I said, your best bet, just bring McDougan in, talk to her, figure out what you got from him, and not only that, but figure out what exactly the lawyer gave her.
Mhm.
Right, because that, not even just in connection with this case, it still be something that needs to be handled, and depending on what it really depends on what exactly he did, because in all honesty, if
Hi, Chase. Hope you're doing well. Good morning.
because if most of the issue was in court while he was testifying, in all honesty, I think that's on you. Because
I mean, true. I did allow
right,
to
so
happen.
I don't think it's fair to punish him for that if he was just testifying based on after being called to the stand.
Yep.
But him giving the phone up and depending on what was in there, what was shared, could definitely be a different issue.
Yep,
But
fair.
again, that's like with my very limited information. So
Yeah, I'd imagine that either you or Case are going to be handling it, because I don't want to fucking handle every goddamn facet of this. I still got another case I got to deliberate on.
it'll probably need to be something that all 3 of us handle together, to be honest.
Probably, yeah.
Probably just call him up, talk to him, have a hearing and whatnot.
Yeah. Anyway, what did you want to talk about?
That's a good question. When did I say I wanted to talk?
I don't fucking know. You've been constantly bugging me about it. It's like, hey, let's have a conversation. I'm like, I don't know, man. It's actually nighttime. Well, good evening.
Honestly, I don't know. I've been told by the Supreme Court to get a meeting with you guys going, to get on the same page as you guys, and when I told them that Judge Case was very non-responsive, I got told to try harder, so...
Cool. Yeah, so basically, I guess that what they're basically looking for is from me to say to you the way I want the direction of the Department of Justice to go. which is I don't want to see any more police cases just because of the drama it causes, even though there are problems with that. And Case has a bunch of other shit. That was the only thing that I wanted. It's just that I don't want to have, I don't want my job as a judge to be ruined by a bunch of police who can't contain themselves by being very dramatic. That was basically my point when I had a meeting with Case.
I got you. Are you wanting, as in no cases like Aaron Rodgers, like PD being charged, or are you wanting no civil suits against them?
Basically, the only thing I want is if someone is coming in to a courthouse who's a police officer, for whatever reason, they have decided that they're going to be there. It's up to them. So it's basically a decision between them getting heavily punished via their career. So 30-day to 40-day to 50-day suspensions, demotions, fucking vehicle removers. I don't care. Like heavy punishments, or they go to court and fight it in court. You know.
I got you.
That's the kind of way. But like, I think Case has like a lot of shit on this that he wanted to talk about.
Yeah.
And I can't paraphrase it because I didn't.
I've been trying to meet with Case for probably 2 weeks now, and every day I'm mentioning him, and he just does not respond to me. So.
Have you tried privately messaging?
No, I haven't.
I'd recommend that.
Yeah.
So
he responds to you in that channel, so I don't know, man. I don't think he likes me very much.
No, the reason why he was responding to me is because he was talking to me about death trials. So I just learned a fuck ton of shit about death trials. Like, holy shit. Like, if this trial went to death, there would be another trial after this.
Yeah, it's more of a sentencing hearing.
Yeah, but what he was talking about... let me pull it up. I'm going to pull up what he was talking about.
Yeah.
Sorry.
You're good.
So there needs to be aggravating circumstances, meaning one of the following of a bunch of shit. So like there's like 9 things that need to be like an aggravated circumstances for you to be able to sentence them to death. And there also needs to be mitigating factors, or if there's mitigating factors, like there's something that would make you want to show mercy.
Yeah.
Yeah, so that's like a whole thing.
Yeah, I know. That's kind of what I took into account. Granted, I did it more so in one trial. I kind of just...
Yeah, so, and it was also stated that technically every single death case trial was wrong. Because we need to do it, like, in its own trial, but it doesn't fucking matter, they're dead.
We only had, like, one early, and again, it's more of just a sentencing hearing, in essence.
Yeah.
It's... But, wow.
Alright, well, McDougan isn't around this early as expected. I need to get some vending machine food. Going to stores suck. Like, they're so shit. You tried eating bananas?
I have.
They're ass.
They're good on potassium.
You know,
But
I
it's
feel
better
like...
than these, like, $97 bagels.
No, you need 15 bananas to fill your, like, from half. Like, not even
Sounds
joking.
like you should just go to a restaurant.
Well, maybe.
I've been ordering pizza a lot lately here.
But, like, the thing is like, I feel like you eat so many bananas that you're gonna get radiation sickness.
I
Like,
think it's a
you're fucking
lot of
popping
bananas
down.
for that. It's like...
That's how many bananas I need to eat. A lot of
There was
bananas.
like a good 200,000, I think. I don't know. It was just a funny video on that. Yeah, $106 for a bagel. 97 for a can of Coke. This
fucking
is
worth it, brother.
inflation is ridiculous. I
Worth
can't afford it.
it.
Holy. Oh, okay.
What do you mean you
Hey.
can't afford it? You got a fucking 100,000 in the goddamn fucking thing. Or, sorry, 16.
Oh no.
16. You're fucking stacked. You're so stacked
Sell
up.
house.
Put it all the thing.
Also, I don't know if you've been seeing them, but Weasel News has actually kind of established themselves as an actual news company.
Mm-hmm.
Would you have any objections to letting them set up an actual... You don't need to shoot me. You could just say no. Holy.
Yeah, I was just making sure my gun's loaded. No objections.
Have any objections to letting them like bring a camera in and record these, if they're wanting to, like record
No.
these court cases?
No, I don't have any objections to that.
All right, then I'll probably send them an email about that. I figured you wouldn't, but
have so much shit. I still have to deliberate on the Richie Bianchi case. I don't even remember, like, what the fuck happened on that one. But I have no idea.
What happened to Richie Bianchi? This is twice now.
He was apparently, it was a bench trial for some kind of drug thing.
Was it drug trafficking again?
I don't know.
I swear, like this is twice.
Oh, I remember. He was saying, "Come to me, and pay me $50, and I'll let you take stuff out of this trunk that's cocaine." But it wasn't his vehicle, and he never opened or physically handed over drugs.
Give me 1 second. I gotta take this call, sir.
Oh my god. Fucking Christ. Big stretch, sorry. Okay. Yeah, I haven't even decided on the Richie Bianchi case. Okay. But after we're done talking to him, I'm pretty sure we're gonna be done with today's stream. There will be another stream though.
Sorry about that. I got a call from my doctor.
I was basically saying that that Richie Bianchi was selling drugs, right? But he wasn't handling it, and he wasn't like it wasn't his vehicle. So basically, the narrative is that he found drugs in a car, or he found white powder per se, didn't like openly or physically handle it in any way, just saw it and then stood by it and said, "I'm selling drugs." And then people came in and gave him money, and then they just opened a trunk and ran off with drugs. So, like, that's really confusing for me, and I needed to deliberate on it because, like, is that constructively, like, thing, or what? Is that actually, like, or is that a loophole?
I mean, was he in possession of the vehicle?
No.
That's the big question. Well,
No, he was just standing by it.
If he's providing access to the vehicle, I would say he's in possession.
He wasn't opening it. He was literally just standing by it. He's never, like, there was one time where an officer, like, basically prompted him to open the trunk, and then he opened the trunk. But I'm pretty sure it was prompted. So, like, it's very strange.
That's just weird.
I mean, shit, he's fucking hustling, I guess, but, like, I don't know if I don't know if that's, like, selling drugs. Because, like, he wasn't in possession. He never handed off any drugs. He was just basically, like, getting criminals to pay him for him to not report a crime that he just witnessed of someone breaking into someone's car and taking stuff out of it. Because that's basically what it was. Vehicle did not come back to him.
Did he say he
reported it to police as well. Like, he literally called police and said, "Hey, there's drugs here," or "I think there's drugs here," because obviously you can't identify drugs off a site.
What did he do? He was telling people, if you give me this money, you can
get
put it
drugs
in the trunk, or
you like give me $50 for some cocaine. And he's basically just telling people it was in the trunk.
Well, if he's saying, like, "Oh, give me this money and I'll give you that," I think that's still him selling the drugs, right? Like,
But he's still not handling it, though.
Yeah, it doesn't really matter. He's still selling the drugs, right? If I say, "Oh, give me 20,000," cool. The drugs are in, go to this house and pick it up. I'm still the one selling the drugs. Right?
Yeah, but his argument was he didn't actually know if it was drugs or not. He was just saying it was cocaine. Now, mind you, coincidence struck that it was actually cocaine, but, like, it's hard to, like, prove against that. Because burden of proof, right? How can they prove that he knows the drugs are cocaine? They can't.
Yeah, well.
It's other than him saying it. See, I'll review that when I get a fucking second.
Yeah, that's a wild case. I don't even know what to say. That's just weird.
Yeah.
Good luck. That's all I can say.
I mean, shit, if he wins, it's gonna be really funny. Because, like, that is a fucking loophole and a half.
Yeah. That's just weird. I don't know.
I mean, shit. If people just open the trunk, they're probably just grabbing all of it, right? It's like, thanks, $50. I'll take all this drugs for how much is in there.
Yeah, I don't know. That's just weird. Oh man.
So what do you got on the docket? What are you doing? Do you have
I
anything?
don't actually think I have anything yet.
Damn.
Yeah.
Well, my deliberation's basically done. I just need to talk to McDougan. I don't think she's gonna be around any earlier though.
Why not? It's July 4th. Oh no, she's from Canada, isn't she?
No, she isn't.
Is she not?
Nope.
It's July 4th, so probably won't be around today at all. I think today is going to be a very quiet day in the city.
I mean, shit. I guess I picked the perfect time to get the old memory started. I think that's what I'm gonna start calling it now, the memory. 'Cause that's how I'm gonna refer to it. It's like, oh, I was just searching my memory. No one can fault that.
I mean, sure.
There's gonna be some hella charges
go
on
with
this guy if this case doesn't get thrown out. I don't think it's gonna get thrown out. I think worst case scenario for the district attorney's office is it gets mistrial, and then another judge will probably preside over it, because I would have too much information at that point.
See, my concern is the fact that if you think there's, like, if you call a mistrial because of the information of what the lawyer provided, that's fine.
Mm-hmm.
But if you call a mistrial because you feel the cop's testimony was tainted, how are you going to, like, even if she were to retestify, how are you going to say that her testimony is not tainted still?
Well, I think at that point you would just get the people who you believe are tainted to not testify, and then have a weaker case because they'd just be working at all the evidence. All the evidence would be, other than like 3 photos, would be admissible, and you'd still have all that, and then you'd have people testify to like what they saw. So, like, for example, like Bobby Dean, like he only came on scene at the pillbox scene where the dude was saying he's gonna kill babies.
What
So,
the fuck?
you know, and sick
What?
babies,
Excuse
apparently. Yeah, apparently that's a thing.
Jeez, okay.
I don't know if that's clarified as terrorism, by the way. I don't think it is.
I don't know, but jeez, man,
Yeah, fucking crazies.
this is messed up.
But yeah, like they'd still have that. They would still have all the evidence. The district attorney would, you know,
Yeah,
I don't know, man. It would be a hard case.
it would be something. But I don't think it'll come to that. I think it'll be fine as long as you're good to not take in that lawyer or whatever was privilege from that lawyer.
Yeah, so the way I did it was I basically I forgot everything after the day because I already had a busy day, and I'm actually pretty good with that with court stuff. And I came in, I reviewed everything. I struck everything from the lawyer's point of view that I had wrote. So it was basically just a summary on why they were allowed to speak about it, what they were speaking about. And then I reviewed it after I gave my verdicts in my document.
And honestly, as long as McDougan doesn't basically say like, "Oh yeah, all of my information came from this lawyer," I don't think it'll be an issue. But there's always that possibility, and that would be something else.
Yep, it's gonna be a thing.
Let's
I
hope
bet.
not. Jeez, what a mess.
This is a month ago too. This is an old fucking case.
Jeez, yeah.
But hey, I got
Honestly-
on early for this shit.
Yeah.
Crack of dawn. No sleep.
Oh man.
Wasn't there another case coming up that you said you couldn't do?
Yeah. If it goes to hold, I don't know. The PD posted in the thing, but I don't think I should be involved. Like, if need be, I can, but
Yeah, that's probably gonna have to be a case thing.
yeah, but you know, he doesn't respond. So
Busy. All right, well, it's nice talking to you. I gotta go and catch some more shut-eye, I guess.
all right, well, have fun.
I am old.
And good luck with that, Kate. When do you like, do you have a date planned for the actual
I don't, but
like,
it's probably gonna
sentencing
be it's probably gonna be tomorrow.
tomorrow? Okay. Cool.
Where is my thing? Hold on. Oh fuck! It changed again, you bastard. Fuck it, I'm wearing this. It's fine.
You are one confusing man, sir.
Ask no questions, hear no lies.
Have a good day.
Okay, ladies and gentlemen, that's gonna bring us to the end of today's stream. I appreciate everyone coming in here and chilling with me for a bit. It was fun to deliberate so early. I don't even know where I parked my fucking car to. It was very fun to deliberate so early. And I know what happened. I forgot to double save. But yeah, we'll be on later on tonight for a thing that is just as serious. We will be having a Leo integrity, we'll be having a supervisor interview on whether someone gets suspended or not, and I get to basically make sure everyone's doing everything because I will be there as a representation for Star. So, like, I want to make sure that everything's up and up because it sounds pretty bad the way he was phrasing it, but I don't have all the information. So I want to, make sure we're all green. So yeah, we'll be having that at 9 p.m. EST today. And that's 7 my time. Mountain time. And we're just doing ovation techniques, by the way. Nothing crazy. Just flying up. Lost squad match, unfortunate, Chase. Love these roads. Let's go. Nice. Now we can wait and see if anyone's following us. Like smart. Want to be smart here. Alright, ladies and gentlemen, that's going to bring us to the end of today's stream. I appreciate everyone coming in, and remember, I will be streaming later on today at, I'd say about an hour before that meeting. So I will love you and leave you. And, wow, what a fucking day so far. Nice way to get my day started. That whole, doing things at certain times, not really working out. Anyway, yeah, double stream today. Double stream. It's gonna be a thing. Anyway, see you later.